No instruction, my lord.
What's your name, madam?
S. Mohanty, Saloni Mohanty.
Saloni Mohanty, on behalf of Amit Prasad Bose, for the petitioner, Mr. Devasis Naik, AGA for the state opposite party. The revision application was filed in the year 2011. The present petition was filed in the year 2011, challenging so-and-so order, passed, dated so-and-so, passed by so-and-so. Though it has been, the matter has been listed on about 4 or 5 occasions, it has been adjourned at the instance of the petitioner. When the matter was last taken up on 1/11/2023, it was adjourned to grant further opportunity to the petitioner. The petition is filed under provision ta likhive, section 30401 read with 397 of the CRPC. Kon likhle? Complete la paragraph, sub para. The impugned order is dated 36/2011, passed in criminal miscase number 504 of 2007 under section 133 of the CRPC, wherein the Learned SDJ Puri declaring the building, quote, Jagannath Lodging, belonging to one Sri Jagannath Prasad Bhagat to be unsafe. And the OP number 2 Puri municipality was directed to demolish the same after the car festival held in the year car festival of the deities, car festival of the deities held in the year 2011. It was further directed by the Learned SDJ Puri that complaint report was to be filed by 1/8/2011. Apparently, the matter has been kept pending without any admission, without the matter being admitted or any interim order has been passed. In considered opinion of this court, nothing would survive at present for adjudication before this court. Learned AGA, referring to the nature of the prayer made in the petition and the subject matter, submits that nothing survives for adjudication. Having heard the Learned Counsel for the petitioner, the Learned AGA, considering the material on record, the petition stands disposed of. Yes, next.
Item 2.
Yes, Ms. Acharya.
Kindly take it up after winter vacation, Your Lordship.
The Learned Counsel for the petitioner seeks accommodation due to non-availability of the arguing counsel. As prayed for January.
4.
आपका जेबे छुट्टी होगा सब करी 4/12/2024 list on 4/1/2024.
Oh, blessed, Your Lordship.
She is so I'm sorry, Arusmita Acharya.
Yes, Your Lordship.
ARU.
ARUS MIT.
Yes, you are next generation of Mr. Arun Acharya.
Yes, Your Lordship.
Yes, Arusmita Acharya. Yes.
Item 3.
Mr. Bharat Bhushan Rautray for the petitioner, Mr. Devasis Naik AGA for the state. Yes, sir.
This civil has already been admitted, my lord. Direction was given to lead this matter up in the order. The last order date, my lord, 31/10/23, but it is wrongly come in fresh admission, my lord. It has already been admitted by last order, my lord. 31/10/2023.
এটা কোন লেখা भी होची माने दत्त कोडे गला Where is he? On 31/10/2023, the following order was passed. Though the matter was admitted and was directed to be listed for hearing, somehow it has been listed again for fresh admission. In terms of the order dated 31/10/2023, list the matter for hearing in its order. In its order, as per the hearing list.
Yes, sir.
Yes.
Item 4,
To be called again at 2 p.m. Next.
5,
To be called again at 2 p.m. Next.
6,
Mr. Simpson Jenna. Yes, 5. 5. You are appearing.
My lords, on behalf of
Your
Mr.
name
Parida-
is. Sorry, you don't have power.
No, my lords, I don't have the power. I'm appearing on behalf of Mr. Parida.
Mr. Parida.
Again,
Your name is
S. Panda, Sudipto Panda.
Mr. Sudipta Panda on behalf of A.K. Parida for the petitioner. Mr. A.G. Devasis Naik, AGA for the state. Yes.
Lords, this is an revision challenging the judgment.
Just kindly speak to the microphone. Yes.
Please, your lordship.
Yes.
Lord, this is a revision against.
I think it
the
will be better
judgment-
if you bend it. The stem ta tolu avri tolu karantu further. Then you just do it like this. Yes. Towards you as you speak. Yes. Towards you. Yes. Next.
Please, your lordship. my lords.
Yes.
Lord, this is a revision against the judgment which is at my lords page 22.
Conviction under which section?
409, my lords.
409.
Again.
So how do you say that it is vitiated?
My lords, I'll just pray before your lordship to kindly have a glance to
Yes.
the judgment of the Chief Judicial Magistrate, which is at page 7.
Yes.
The case of the prosecution was that one Mr. Michael Datta, who was a resident of Gopalpur, had deposited a gun which was an English barrel Boriswell gun before the Gopalpur PS on 4/1/1997 because of the elections which were going to be held therein. And subsequently, it was stated that the gun was given on the issue by the present petitioner here, Millets, and it was thereafter not returned to the complainant, Millets, that is Michael Vidara, for which an FIR was lodged.
So he's a government official. He did not return it.
Yes, Millets, that is the allegation.
That was not in his personal possession.
Yes, Millets. So 409 was anyways, Millets, is not attracted.
No. How do they prove that?
Millets, I'll place the evidence.
How do they
also.
prove that it was in possession or somebody? Because then it would not
Because
be
the informant who has been
409 is
14,
CBOT or what?
Millets?
What is 409? CBOT or what?
No, Millets.
breach of
409
trust.
is criminal. Millets, just please. Government servant.
Yes, CBOT.
Criminal breach of trust by
Yes, that
public
is
servant.
thought that is called CBOT. Yes, next.
Again. So here, Millets, it was alleged that during the time of elections, it was stated that everybody has to deposit their guns, for which the informant had
So
to
that point is well taken.
again.
He deposited. But what is the nature of proof that he has
It has been
taken away the gun?
stated by the informant who is examined as PW 14 that he has deposited.
No, what is the method? Because I think that's an armory or something. You have to go there and it will deposit. It's kind of a government custody.
Millets, it is like Millets, you have to go to the PS Millets, you have to deposit where challans are registered. Challans are given to the person who is delivering, and as well as the challan is kept in
This
their
fellow was
plan
working.
register.
This fellow was
He
working as
was
what?
ASI of the Gopalpur
Okay.
PS. And the other co-accused who has since been acquitted, Millets, he was the officer in charge. That is one Shantanu Panigrahi.
Yes.
Both stood trial, Millets. Both had stood trial because of.
So what is the issue number 2 where it is answered?
Millets. The courts have framed 3 issues, Millets, which
Yes.
is at page 11.
Yes.
That the accused
Where because public servant is not disputed. Where is the answer to Which
that
paragraph?
he was in such capacity entrusted with the property in question with dominion over it. That has been answered, my lords, on the next page. Your lordship may see.
Straight away come to paragraph 8, internal page 5.
Lords, the next point relates to the nature of entrustment. Lords, the highlighting portion is, if your lordship may see the next part. Coming to the standard of proof left in the next instant case, informant PW 14 alleges in his evidence that the accused.
So, Poda, since it is an order which has been, again, it is it's in nature of a revision.
Yes, my
So, I
lord.
have to understand what is the reasoning. So, you
My lord, I'll place
stick to paragraph 8.
Paragraph
Yes, my
15.
lord. The next point relates to nature of entrustment of the property. And in the present case, it refers to a 12-bore
Here the petitioner is Rameshwara or Sanatana?
Rameshwar, my lords.
Rameshwar.
Sanatan has been acquitted, my lords. English make Charles Boswell gun as per the allegation of the informant. In the event of discharge of such onus by the prosecution about entrustment of property or the accused having dominion over the same, prosecution has to prove that the accused committed criminal breach of trust in respect of the same property. My lords, next page. Coming to the standard of proof led in the instant case, the informant PW 14 alleged in his evidence that the accused Shantanu Panigrahi, who is the co-accused, my lords, who has been acquitted, who was the OIC officer
No,
in charge of
what I'm asking is bit nuanced. So,
Okay.
so my query to you is that it is an unusual conviction. Let me tell you.
Okay.
That is what coming to my mind. It's a process involved.
Yes, my
He
lord.
must have got a receipt.
Yes, my lord. That is all stated, my lords.
That
Why
is
do they say that there is CBOT?
That is in paragraph 15.
That is
That conclusion is in paragraph 15.
No, what is the evidence for
Simon-
paragraph 15?
Malice. The receipt that was given, that was duly signed, the entry in the gun register, and his colleagues who were there present in the police station at that.
Everything has been marked as an exhibit.
Yes.
Register is there.
It's
Yes,
the
receipt is there.
His receipt is there. His signature is there.
Yes. So it was found missing from where?
from the Malkhana, PS Malkhana.
Malkhana. So who was in charge of Malkhana?
My lords, PW3, if your lordship will see, he's the person who has received the gun. It was not the present petitioner. Your lordship will kindly have a glance to the evidence of PW3. May I place it?
It's not a mal item actually. Though maybe they have kept in the Malkhana, but so mal item, it's different. That's the procedure is different. But here they are received and it is supposed to be returned after the
Again.
elections.
Because other guns of other persons were duly handed over, my lords. As I am placing PW3, I know both he is also an ASI of police. Lords, I know both.
DP ହେଇଥିଲା?
Again?
Departmental proceeding ହେଇଥିଲା?
My lords, I believe there was one. I have no instructions, specific instructions, my lord. I know both the accused persons. Both of them were attached to Gopalpur PS in the year 1997. I know the informant who is a hotel owner at Gopalpur. On 4/1/1997, I was a police constable attached to Gopalpur PS. Accused Sanatan was the OIC, who is the co-accused, my lords, of Gopalpur PS. On that day, he was absent. Since the case was that he was absent, that's why he was acquitted, my lords. That is the from the police station and had gone to give evidence before one court. Accused Rameshwar, who is the present petitioner, my lord, was the in charge of Gopalpur PS during the absence of OIC. There is nothing on record which shows that he was given the charge on behalf of the co-accused.
That
my lords.
gun was recovered or never recovered?
No, my lords, it was never recovered. During the
Then it is-
absence,
But it was kept in the Malkhana.
yes, ma'am. The gun register is there, which PW3 category states that at the behest of Rameshwar Satpathy, I had entered the register and I had given one slip, Xerox slip to the informant.
That Malkhana register?
That Malkhana register, my lords, I have to go through the LCR because I have not seen.
Then what is the basis of conviction, Mr. Naik?
Lord, there is nothing.
And mens area
in
is
the
also
judgment,
lacking, my lords.
There is nothing mentioned about the Malkhana. So whether the
Then who says that
I will
it was
just
taken after
I will just place that paragraph is very
Yes.
material. I just place.
No, anything that comes to your notice that I was asking.
No, because he received the gun.
But here LCR has not been received or it is yet to be admitted.
No, my lords, this was admitted and he's been granted bail.
Then it's
No admission houni. What I find in the tenor of orders that initially that is so it is left out to be considered in a subsequent date.
Okay. I am sorry, my lords.
So he received the gun, he gave a receipt. The judgment does not ask.
He actually, when you are saying he, because that's the presumption by this the Lord Trial Court.
My lord.
It's an official process. It is received in the PS. There will be some human being. It is entered in the register. It is kept in the Malkhana.
It is kept in the Malkhana does not reflect anywhere, either in the judgment of the trial court.
Then
or
somebody has to say that somebody has
My
taken away. Then because you see, it is not as such handed over to this particular person.
Well, he says,
At best, it can be said that he was in charge of that police station.
my lords, I'll just read that so that my lords, this is on this is paragraph 15, page 10, internal page 10. The investigating police officer PW 16.
So let the LCR has come. What is the noting?
I think the scanned copy of the LCR, my lords.
Yes, LCR is
come.
there.
There is a barcode, so this is.
এটা जो स्कैनिंग करछथि फास्ट अपील टा रहला बाकीटा कोडे गला देखंतु चारटा जे आपण जबा करछथि फ्लैग मार्क बुक मार्क चारटा हले केमति हबो फर्स्ट एक्शन सेशन जज बरहमपुर क्रिमिनल अपील एटा आपण लिखि रखंतु यू ट्रेन देम There is no page mark, nothing. The court of the first instance is which? What is the name of the
My
court?
lords, it is against the judgment of the first additional session judge Barampur Ganjam in
Yes.
criminal appeal number 2
So
of
the criminal
2030.
appeal was filed against which order?
My lords, this is against the order of the additional session judge.
Mr. Sudipta Ponda for the petitioner, Mr. Devasis Naik on behalf Sudipta Ponda on behalf of A.K. Parida. Devasis Naik, AGA for the state. The scanned copy of the brief shows that the LCR has been received as per the barcode number. On opening up the said scanned copy of the said LCR, the bookmark shows table of order sheet, judgment, wakalatnama without giving any details or pages of the contents of the scanned copy. Registry shall also verify if the records from the learned court of the first instance has been received as directed by directed by a coordinate bench by order dated 25/3/2014. If the records of the said original court has not been received, the same shall be called for. Scanned copy shall be updated. When do you want?
And it's any day convenient to your lordship, preferably leaving aside the last week of this month, as I will be out of station, my lords.
December dekhantu? Because they have to call for and arrange it.
Lordship may grant it on the first week of
Kon
January.
dekhi koi paribe achi ki nahi? See dekhantu samay nashto khali kare. Sorry?
January
7th of December.
Lords, I don't think it will reach by that time.
What can be done?
Lords, by January, if your lordship will post it, it will be convenient.
Dekhiye, let us try.
Okay.
At least they
Okay.
can comply.
8th, my lords, 8th.
8th of December 2020.
Grateful, my lords.
Register to do the needful.
Item 6,
Let's see, item 6, paying for adjournment on behalf of Sarthak Naik.
Mr. Simpson Jena on behalf of Sarthak Naik for the petitioner. Opposite party blank. The learned counsel for the petitioner. 6 accommodation as paid for list on 5th of December or further time.
5th of December.
5th of December. Name of Mr. Sarthak Naik be indicated in the cause list as well as the case brief.
Much obliged. Let's.
Yes, next.
7,
May it please your lordship.
Yes.
This is leave to appeal, my lord,
Yes.
against a judgment of acquittal by way of default and appearance. The
Yes.
acquittal is owing to the default and appearance since it is a complaint case filed under NI Act. Last date, your lordship, I was unable to give the legal certificate of the complainant because the complainant has died in meantime. The complainant's son has filed this appeal, leave to appeal. So your lordship may kindly accept the
So
memo.
Ramaben Patel, no, you amend. You have to amend. I can't accept a memo. That will be affidavit.
No, Ramaben Patel's son has filed. Already Ramaben Patel was dead in the lower court.
You see the last order.
My lord.
Since the legal heir of the late Sibaji Patel, Sibji, it's Gujarati.
My lord.
Sibji Patel is not the complainant in the 1cc case, and it is his wife, Srimati Ramaben Patel,
Yes.
who is the complainant. When a query is made to the learned counsel for the petitioner, whether Srimati Ramaben Patel is alive or dead, he wants to obtain instruction the same.
Yes, now the confusion arose because the copy of the legal heir which I had submitted, that is Annexure 3, is of
No.
Sibji Patel. Sibji
No,
Patel.
Mohan Patel, whether this can inherit this right to sue.
Yes, because the legal heir can inherit the right to sue, my lord. In the
Which
complaint
provision?
case.
Which provision?
Complaint case, right? Section 2.
Then first you come to 138. Negotiable Instruments Act.
138 and 9. One 38. Section 138 of the NI Act, there is no specific mentioning regarding whether the legal heir can inherit the right to sue. But I have judgment I have come across that is also there. I couldn't bring today.
So bring that.
Yes.
Bring that. Because per se, he's not a debt. He's not a, I mean, what you call. So nothing is due to this Mohan Patel.
Yes, but if it is due to the deceased.
But after acquittal,
Married.
after acquittal, this during pendency of the proceeding, Ramaben was alive.
In fact, was dead, but that couldn't be brought to the notice of the learned lower
Then
court.
still worse.
So thereafter,
Then how the lower court proceeded? Because the complainant was
no,
dead.
because
Was examined.
lower court proceeded as nobody appeared. On default, it was dismissed, not because of the death.
Default due to death,
No,
not
no.
because of death. That's a wrong statement on the face
Default
of
due
it.
to non-appearance of the complainant.
Non-appearance of the complainant who died.
Yes.
That's your case.
Non-appearance of the complainant who had my reason for appeal is because she had died and that was not brought to the
So suppose see, it's not that due to default. She died due. It was dismissal due to default because of death of the reason being the death of the complainant.
my lord, here
Then what would happen?
in case of death of the complainant also there is a provision for acquittal. But here because owing to the default
So that provision
256 section 256 my lord.
CRPC.
Yes my lord.
Yes.
CRPC 256.
Yes.
Non-appearance or death of the complainant.
This has been dismissed referring to 256.
256(1). That is owing to non-appearance. But later it was found that the complainant has died And that is my reason to appeal, that because she has died, it could not be brought to the notice of the Honorable Court, the learned lower court. So that is why I have filed this appeal. Now, this provision says 256, non-appearance on or death of the complainant. If the summons has been issued on complaint and
So
on the
two,
day,
it is both 1 and 2. So it could not have been 2 because by the time the court did not notice death of the complainant.
yes. So it is
not
only
1.
under 1. 2 is relating to the
You are
death.
not, suppose you say that there is a bona fide reason for non-appearance, then 1 will be considered.
Yes.
It is both 1 and 2. So in case of 256(2), what would happen?
The provisions of section 1 shall so far as may be applied also to cases where non-appearance of the complainant is due to his
That
death.
point is well taken. After dismissal due to 256(2),
Yes.
what would happen?
Due to 256(2), the right to sue also survives.
So that which provision in CRPC?
CRPC, that I am.
So not that there has to be a provision.
Yes, yes.
Notwithstanding anything contained in any provision or 256(2), the right to sue shall subsist in
Yes.
case of dismissal of non-appearance.
I have a judgment law on this also.
देखो
Again.
or else it is Sironasti Siropida.
And the
other problem is that in NI Act it's technical. Everything is defined. 138 is a quasi criminal. It's not exactly criminal. So there has to be. So who will prove that that something was liability was there, to pay was there, dishonor was there, issuance was there? If the person died, then who issued the notice then?
Now, by the time the person was alive, the notice was there, was issued. That
I don't know. I'm not talking about this case. I'm asking you.
Yes.
When you are assisting in all these points, you have to look into that.
Yes, I will definitely.
Yes,
I'll
you
come
have
up
to
with the answers.
go into that whether there was a notice. Then who issued the notice? Because then the interpretation would be that anyone can issue notice on even on behalf of a dead person or in absence or because that's not contemplated in this NI Act.
I got your lordship's point.
Please. Thank you.
Grateful, my lord. For
No,
me
not
to
at
get
all.
enlightened also.
Sorry.
For me to get enlightened also.
No, not at all. Not at all. It's the bar. Obviously, the judge gets educated by the bar. What is there?
Yeah.
Yes. So Anupam Ratha for the petitioner. The learned counsel for the petitioner submits that in terms of the earlier order passed by the coordinate bench dated 1/9/2023. He submits that he has received instruction that Srimati Ramaben Patel is dead, and it is further submitted that as per his instruction, Srimati Patel died during pendency of the proceeding before the learned court of the first instance.
Yes.
In view of the above facts, the learned counsel seeks further accommodation to advance arguments. As the petition has been before the learned court has been dismissed. Language कौन use करचंदी से?
Sorry, madam.
Trial court कौन language use करचंदी?
The non-appearance. Dismissed. And acquitted.
Due to and the opposite party was acquitted, referring to the provisions of 256(1)/256(2).
256(2) he has not mentioned. 256.
Mr. Ratha, I don't know how you are stuck. I don't expect you to be stuck like this. You see, 256(2) he could not have resorted to.
He could not.
Because why?
Because he had no knowledge regarding
Exactly.
that.
So now you are submitting that it is also 256(2). And 256(2) is interestingly, the wording is very interesting. 256(1) can also be due to death of the person. You see the language again.
Yes.
Please kindly mark the language.
The provisions of 256(1) will apply to even 256(2) cases.
So death is as good as non-appearance. That is my understanding.
Yes.
If you read 256(2), the provisions of subsection 1 shall, so far as may be, apply also to cases where the non-appearance of the complainant is due to his death.
Yes.
But why 256(2) then is there?
That is mutually exclusive also.
No, it's not exclusive.
Exclusive 256 2
it
only
can't
can
be.
also.
It can't be mutually exclusive because of the section makes it inclusive. Then the next question is logical question would be then why 256 2? The reason being the court will not be aware. Second aspect, that non-prosecution due to death is also due to non-appearance. And you see that two straight away says the provision of subsection 1. You can't be mutually exclusive.
Non-appearance owing to death also 256
Yes.
2. And simpliciter non-appearance for default. My lord.
So when dismissing for simplicity or non-appearance, when summons are issued to the complainant,
My lord.
this is being done not in these cases, in all criminal cases. Because in many cases, complaint cases, the complainant is not coming, informant is not coming. So those are being consigned to dormant file also. Because if you look at NGDG, the pendency is not actual pendency because that includes many cases where 256 1 and 2 could have been resorted to.
My lord.
Yes. Next, please. Date colleague. 7th of December or for that time? 7th December. Please examine.
Yes, ma'am.
Item 8.
Let's see. Item 8 can be taken up.
Mr. Khogeshwar Behra.
Let's
Mr. Khogeshwar Behra on behalf of Aniruddha Das for the petitioner. Mr. Devasis Naik AGA for the state. Learned counsel for the petitioner prays for further time to advance arguments due to non-availability of the. You have power here due to non-availability of the arguing counsel. So, apna K Behra khali lekho. K Behra. As to grant further opportunity, list on 4th of December.
let's
4th of December 2023.
Item 9.
Case diary is available.
My lord. Yes, it is.
Now, it's AGA submits that the case diary is available as indicated. Sorry, the learned AGA reiterates his submissions as indicated in order dated 16/10/2023 that case diary is available, and that the petitioner has one antecedent involving criminal allegation of similar nature. Yes. Next.
Item 9.
May I please, your lord, sir?
Yes.
The praying for an adjournment.
You are Mr. Raut.
Yes, my lord.
Mr. B.B. Raut for the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner seeks accommodation to advance arguments. Seeks further accommodation. As prayed for, list on 6/12/2023 to grant further opportunity. The learned AGA submits that he has received the case diary.
Please.
Item 10.
Item 10, my lord, on behalf of Satyavrata Panda, matter may be taken up 3 weeks after, my lord. About telephone, he instructed me to take.
Mr.
Ekke
I'm
Jena.
sorry, your name I have forgotten.
Ekke Jena, Asit Kumar.
Mr. Asit Kumar Jena on behalf of S. Ponda for the petitioner. The learned counsel for the prayer for adjournment is made on behalf of the learned counsel for the petitioner, though it was granted earlier. To grant further opportunity, list on 7th December 2023. The learned AGA submits that the learned AGA reiterates his submissions as noted in the order dated 19/10/2023 that case diary is available and there is solitary eyewitness regarding the incident alleged against the petitioner. Yes, next.
11.
May I please, your lord?
Yes,
My lord, case is 20.
Mr. Rajiv Lochan Patnaik for the petitioner, Mr. Devasis Naik AGA for the state.
Call for the CD here.
Mr. The learned AGA seeks further accommodation to obtain the CD and criminal antecedents of the petitioner. Case diary as well as the as well criminal state kati diyantu, as well as allegations, as well as information regarding past allegations against the petitioner,
10 days, my lords.
if any.
My lords.
How much time, Mr.
10
Naik?
days.
As prayed for, list on 28/11/2023. Today is 14th.
First
Today's
December
14th.
mana
December 1000.
mana
Cordial.
oblige lords.
Chari bar.
The learned counsel for the petitioner seeks accommodation further, also seeks further accommodation as prayed for. List on 4/12.
Oblige lords.
12.
I will permitted to withdraw the bail, please.
Mr. Lakshmi Narayan Royat Singh for the petitioner. Mr. Devasis Naik AG for the state. When the matter was last taken up on 13/10/2023, the following order was passed. Para. The learned counsel for the petitioner
Filing my withdraw petition.
files a memo indicating that the petitioner doesn't want to press the present petition and the same may be permitted to withdraw. Memo dated 14/11
Yes, lords.
filed by the learned counsel for the petitioner is taken on record. The petition is dismissed at this stage. Yes, next.
13.
To be called again at 2 p.m. Next, please. Yes, next.
14.
To be called again. Yes.
15.
To be 15.
My lord, I'm seeking for an adjournment.
Your name, sorry.
Vaishali Mahanti, B. Mahanti.
Vaishali Mahanti on behalf of PK Sahoo.
PK sir.
For the petitioner. You have power here.
Yes, my lord.
You are advocate on record also.
Yes, my lord. My name is on the cause list.
Yes, yes. So like on behalf kati diyantu. Miss apana Mr. Lectundi M.S.B. Mahanti for the petitioner, Mr. Devasis Naik AGA for the state. When the matter was taken up on 6/11/2023, the following order was passed. Quote kar debe. When the matter is called today, the learned counsel for the petitioner seeks accommodation to advance arguments. Para. As prayed for, list on 30/11/2023 to grant further opportunity. When do you want? In December?
In December, my lord.
December Koran. 5/12/2020.
Yes, sir.
Yes, next.
16.
Your name, sir?
Bisubsun Das.
Mr. B.B. Das for the petitioner. Mr. Devasis Naik AGA for the state. When the matter was taken up on 6/10/2023, the following order was passed. The learned counsel for the petitioner seeks further accommodation. As prayed for. So, para as prayed for list on 1st of December.
December 2nd week.
Second week deal. List on 11/12/2023. To grant further opportunity. CD is available. The learned AGA submits that case diary is available.
Yes.
17.
Item 17 pray for warning after money.
Your name, sir?
Divya Jivan Misra.
You have power here. BLAPL 7498.
My lord, my power is there, may be recorded 1 week after, my lord.
So Pratik Naik for the petitioner. But why so many counsel or it has been transferred?
It has been transferred, my lord.
Then
the previous council,
Subhendu Naik and
they have transferred it, my lord.
Okay. This is item 17.
My lord.
It is Mr. Pratik Naik submit on behalf of the petitioner submits that he has entered appearance in after retirement of the earlier counsel who were appearing earlier on behalf of the petitioner. Name of Mr. Subhendu Kumar Naik and associates be deleted from the cause list as well as the case brief. Retaining the name of Mr. Pratik Naik and associates. Para, the learned counsel for the petitioner seeks accommodation to advance arguments as prayed for. List on 6/12/2023.
Case diary is available.
The learned DGA submits that case diary is available. Yes, next.
18.
So Asit Kumar Jenna for the
any
petition.
previous date if possible. I humbly pray for any previous date.
केबे कहले
Short date.
केबे कहले
6/12
आपण केबे कहउचंती
पूर्वରୁ ଟିକେ
28/11 28/11/2023.
much obliged man.
Yes.
18.
Mr. Asit Kumar Jenna for the
Make
petitioner, Mr. Devasis Naik AGA for the state. The affidavit copy you have served.
My lords, he served affidavit copy.
So it is in sync with your instruction.
No, I have not yet. I'll see with also my lords had asked for TI parade identification report. That also hasn't come.
Here the BLAPL 7139, 7140, 7136.
That is in respect of the another case, my lord, affair, my lords.
Not this affair.
No, my lord.
So
7136,
Pradhani Jani will not cover this.
No.
In fact, my lords, the 2 criminal antecedents I've just verified from the CD. There are 3 criminal antecedents,
Including this case.
No, Mr. Jana, if that has been rejected, you are in custody.
I'm in custody, my lord.
But there is a possibility that you get bail in this case.
My lord.
And move the. But the problem is that anyway, this Pradhani Jani will has created complete. Then the other matter, the other case has to go to that bench.
No, my lord. Because my lords, not arising out of same affair.
7139 subsequent application in change circumstances.
That is in respect of that case, my lord, that affair, my lords.
That is how I asked you. 7139 after rejection, you are in custody.
My lord, I'm in custody, my lord.
So 7139 will always be there. Rejection order will be there, or it has been challenged?
There, my lord.
So this bail application, assuming that it is allowed, still then 71 due to 7139.
Your lords.
7139 again you have to move that bench.
There, man.
That I was trying to understand.
And so far
but you are saying that since it is a different affair, so it has to come to before the roster bench.
My lord.
And now this is the roster bench.
My lord.
And Mr. Asit Kumar Jenna for the petitioner, Mr. Devasis Naik AGA for the state. The learned counsel for the state seeks further accommodation to obtain instruction in response of the in response to affidavit filed on 2/11. Affidavit filed on 2/11/2023 on behalf of the petitioner indicating past allegations of criminal activity, if any. Stop. How much time, Mr. Naik?
Well, it's 10 days TI parade.
As spread for list on 28, 29, or you want further time, Mr.
Yeah, lordship, please, yes, my lord.
1/12/2023.
But this is an order dated 25/9/23, my lord.
25/9 earlier, prior to this assignment, my assignment.
There that identification report had been called for. That I think will take some time.
No, you are saying 25/9.
My lord.
This is which BLAPL? 7546.
7546.
I don't find any order. But the physical copy ta verify karibe. There is some issue. Maybe some connected case it has been mentioned. I don't find. You see, I can. Read it aloud. 21/7 is the first listing, order number 1, along with BLAPL 7136. So today 7136 is listed, or it has been rejected there.
Rejected there, my lord.
They are rejected. Then the petitioner has to file affidavit indicating past criminal proclivity, state to obtain case diary.
My lord.
Then order number 2.
11-9.
Oh, yes. That is 11-9. You said 5-9 or 11?
11-9. 25-9, 11-9, both.
Move 25-9 is not there.
Then 11-9 order.
कौन लिख ले? The state shall obtain up-to-date case date लिख ले. As directed by order dated 11-9-2023, the TI parade report, if any, shall be produced.
Lordship fixed one.
Report regarding TI parade, if any कर दियो. पर के बेटा को एक बार डेट के 1st of December you want for further time?
No, ता पूर्व हेले भी चलिबो.
से आणंतु हेले से गोट से वीक रे रहू आ कोन.
So for this sub item we concern, my lords, your lordship may pass same order, my lord, because
नहीं सितरे कौन से ऑर्डर अच्छी ना तो भूलभाल ले जो आप तो प्रधानी जानी the things are getting very complicated, difficult to list matters, to understand which order in which FIR, and this aspect perhaps has not been taken note of. I have no problem with pradhani jani, but this is a case where 3-4 FIRs is lost against one person. In one, bail has been rejected. The other, there is a direction to produce a report. Then the assignment is somebody else's assignment. So I can't send it there because it is now my assignment.
नहीं सब आइटम रे भी सेम ऑर्डर होबो काहे कि ना से क्षेत्र भी
11-9 ऑर्डर ना को ऑर्डर सेटा पचार जे
सेटा अछि 7546 रे भी अछि सब आइटम 7547 रे भी अछि
11-9 ठीक अछि. You are right. 11-9 there is an order to produce the TI parade report.
My lord.
इतरे 25 ना ऑर्डर ता इतरे अछि कि नहीं no 11-9. Yes, next कोडा कहउछंती
सब आइटम रा सेतरे कि दीटा कनेक्ट अछि
7547 अछि.
My lord.
Then what about 7139?
7139 that was
record asini ko
7139 that
is dismiss heichi.
All are rejected in that in view of that FIR, my lords. Separate file itla all accused
that order is there,
my lord.
The records of 7139 sabuthre lekhi diontu 7139 BLFL 7139 of 2023 disposed of on 11-9-2023 shall be called for reference, scanned, scanned, and the scanned copy be updated. Yes, next.
Se sub item re bhi se TI parade report anibe au.
Yes. I've already passed that order. Since you are the same setup council, I simply said him that
1st of December, man.
1st of December.
Great.
19.
I may please, your lords.
Yes,
the petitioner is in custody since 9/5/23 under section 420, 294, 506 of IPC.
What is the nature of allegation? Targeted
1,60,000, my lord. He has taken from one witness, Surendra Sahu, not from the complainant. As per the charge sheet, my lord.
No.
Charge sheet has been submitted.
No, sir. I am asking what is the nature of allegation? That he tries to collect money from people to sell them plots, give employment.
Only one criminal antecedent, my lord. Only one case.
How many persons he has exploited or cheated?
Only this complainant.
Have you filed affidavit?
My lord.
When did you file that affidavit?
I have.
This is 7552. 7552 BLAPL.
7552.
Chandrakanta.
My lord.
I don't find any affidavit.
16/10/23, my lord.
What is the status? JMFC pending before JMFC.
My lord.
You have received copy, Mr. Naik. Then what is your instruction?
There is no criminal antecedent apart from this one.
Apart from this, there is no antecedent. The Mr. Kuresh Prasad Das for the petitioner, Mr. Devasis Naik AGA for the state. You have received a case diary and on basis of Devasis Naik AGA for the state opposite party, state. London Council for the petitioner submits that the petitioner is in custody. Second para lecture. First para gola, the petition has been filed. Second para, petitioner is in custody since
9/5/23.
9/5/2023. Considering the nature of allegations, the petitioners may be shown indulgence as far as prayer for bail is concerned. Stop. It is further submitted that the petitioner, being a local person,
My lord.
has roots in the local person, comma, having roots in the society. There is no possibility of he escaping the jurisdiction of the learned court in season of the matter. Stop. It is further submitted that the petitioner shall abide by any condition that shall be imposed for grant of bail.
My lord.
Para. The learned AG, referring to the materials contained in the case diary furnished by the investigating agency, opposes the prayer for bail. Subpara, however, comma, it is not disputed that the affidavit filed on behalf of the petitioner through his wife, contents of the affidavit, the contents of the affidavit filed on behalf of the petitioner through his wife, indicating the past allegations of criminal activity are correct. The said affidavit discloses that Mancheshwar PS case number 194 of 2023 is pending before Learned JMFC -Roman 2 Bhubaneswar. Para. Having had Learned Counsel for the petitioner and the Learned AGA for the state, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the Learned Court in season of the matter, which shall also contain a condition that any violation of, comma, deviation from, not comma, oblique deviation from, then comma, any of the conditions that would be imposed for grant of bail shall result in filing a petition for cancellation of bail by the law enforcement agency, oblique complainant, oblique informant, disposed of accordingly.
Deeply pressed.
Yes, next.
Item 20.
20, my lord, I pray for an adjournment.
Mr. BC Parija on behalf of the petitioner, Mr. Devasis Naik, AGA for the state. You see, it was refused on 30-10, noting that earlier the Learned Counsel for the petitioner yet again prays for adjournment to grant further opportunity to the petitioner list on 30/11/2023 or even further time.
First week of December, my lord.
December कर दियो.
7/12.
7/12/2023. The Learned AGA submits that
Case diary is available.
case diary is available.
21.
Can be adjournment.
Mr. S.K. Patnaik for the petitioner, Mr. Devasis Naik AGA for the state. Now, CD पढ़ी देले ना कौन Mr. Patnaik? CD पढ़ी दीजन ना कौन?
Copy टी दरकार apply है तो 12 तारीख रे
5th December 2023. The Learned AGA submits that case diary is available. Sub item, Mr. Patnaik. Same. Okay.
Another quick.
Yes.
22.
Mr. Saroj Kumar Padhi for the petitioner, Mr. Devasis Naik AGA for the state. Yes.
I place for adjournment.
Yes. The Learned Counsel for the petitioner yet again prays for adjournment. As prayed for Sapara, as prayed for list on 4th December 2023 to grant further opportunity to the petitioner. The Learned AGA submits that case diary is available. Yes.
23.
May I please, Your Lordship?
Yes.
My lord, offense under section 20B2C of NDPS Act.
You are Mr. BP Misra.
Yes, my lord.
Past antecedents?
My lord, no antecedent.
You are filing affidavit?
No, my lord. I have not. Last occasion, Your Lordship was directed to obtain instruction regarding.
It has, no, yes, it has been recorded.
Yes,
it has been recorded.
My lord, I have not yet received.
Okay. Mr. BP Misra for the petitioner. How much time, Mr. Naik?
10 days.
Mr. Devasis Naik AGA for the state. The Learned AGA seeks further accommodation to obtain the case diary and instruction regarding past allegations of criminal activity against the petitioner, comma, if any. Stop. List on 29/11/2023. Yes. Yes. Mr. Ponda, you have. Achha.
24. 24.
May I please your lordship?
Yes.
A case under section 21C and 29 of NDPS Act. The petitioner is in judicial custody since 4th December 2022.
What is the quantity and past activity?
Only one antecedent and quantity is 1
1
kg 33.5 gram. But the seized brown sugar has not been seized from the possession of the petitioner. Annexure 3, my lord, page 36.
I'll have to obtain the CD, my lord. But anyway, this is a huge quantity, so
Obviously.
and so, my instructions are.
They have not sought for legal advice.
It's an interstate.
120 grams each. Interstate or.
STF has taken over the investigation because of
the root cause, the drug peddler.
Sir, in all cases, you should find out the origin because these are all peddlers.
Here, Malad, they have gone, Malad.
I'm sorry, only conduits. They are not peddlers even.
They have gone into Malad. STF actually doing all those things, Malad. Now, Malad, they are doing, Malad.
The petitioner has 3
huge quantity. 1 kg 300 something.
Obviously, it was not. So that is how why the surprisingly everyone is carrying 120 grams.
The petitioner
or something kind of soup 120 was 121, 111.
Actually, this person was about to distribute and he was captured.
That is the then you are throwing the same idea as I am having in thinking.
During the interrogation, those has come.
No. The petitioner has not similar type of antecedent.
No, sir, the quantity is quite high. And that is how after your arrest, they have been consulted and they have all are carrying 120, 110 grams. Most of the cases, it is 120, 110, not even 200. Very, very strikingly similar quantity carried by each person. So you are Mr. Tripathi?
No, Swayam Prakash Das.
Mr. Swayam Prakash Das for the petitioner. He is from the state. He belongs to he's a local person.
Local person.
You should be proactive. You should obtain local security.
Yes.
All those things.
Yes.
You should be ready with that.
Yes.
Because you filed it on 13/7/2023. After 4 months, we are discussing today where you are ready to furnish. Once you see the tenor of the order, the trend of the orders passed by this court,
yes,
you should be ready with that. What is his age?
33. Having small children and old ailing parents.
How much time, Mr.
It's 2 weeks.
2 weeks. Mr. Swayam Prakash Das for the petitioner, Mr. Devasis Naik AGA for the state. You have sought copy of the affidavit, Mr. Naik?
Yes.
Yes, my lord. Yes.
The learned counsel for the petitioners submits that he has already sought the copy of the affidavit on behalf of the petitioner filed through his wife dated 13/10/2023 on the learned counsel for the state. The learned counsel for the state seeks accommodation to obtain instruction in response to the same. It is further submitted that further time may be granted to obtain the up-to-date case diary as well as antecedents pertaining to criminal allegations, if any. List on, today is 14. List on 30/11/2023. Yes, next.
25.
Wait, please, my lord.
Yes.
My lords, on behalf of the conducting counsel, he is taken ill. I pray the matter may be adjourned.
Ms. Ayushi Mehta, M.S.A. Mehta, on behalf of Naresh Naik, Mr. N.K. Naik for the petitioner. Mr. Sahoo or Mr. Boral, you are there for the informant. Where is Mr. Boral? Mr. Standing Counsel for the state. Informant, none. None appears for the petitioner, though the learned counsel for the petitioner, prayer for adjournment. Sorry, Lekhontu, the prayer for adjournment is made on behalf of the learned counsel for the petitioner to grant further opportunity. That day, actually, they were present in the court. This can't be granted, Miss Mehta. You inform him. On 7/11, everyone was present, everyone was heard, but the petitioner did not cooperate, learned counsel did not come, it has been adjourned. So inform. It will be taken up at 2 p.m.
He's suffering from fever, that is why he is requesting.
So he has to read. After, it may be a coincidence, after reading the order dated 7/11, he is having fever. And usually I find in all cases that there is dengue, the platelet goes down. So at least after disposal of the case, you will have a better health. You see, the court and the system is not at the mercy of somebody. He has to engage somebody to appear.
My lord.
Yes. Yes. Further opportunity, no. On 7/11/2023, none had appeared for the petitioner, though the matter was called twice over. And the following order was passed after hearing the informant, the mother of the victim, present at the virtual court of the Odisha High Court at Rourkela, Sundargarh. On the said date, the following order was passed after hearing the learned counsel for the state and going through the statement of the victim recorded under section 164 CRPC. Despite sufficient indulgence being sold, and the following order was passed, despite sufficient indulgence having been shown to the petitioner, no one is appearing for the petitioner to advance arguments. To grant opportunity as a last chance, though the petitioner is otherwise not entitled for the same. List on. Tentatively, any date for recovery he has suggested when he will be recovering from fever?
2 weeks.
Which fever will be which he can refer in 2 weeks?
My lord, he is undergoing tests.
Either you see, have you heard this from any doctor?
My lord, he informed me over the phone.
What is about viral fever? If you take medicine 7 days, or if you don't take medicine 1 week.
I concede.
So if it is a fever which goes beyond 1 week, then it can't be cured. Instead of telling don't take medicines, they say that if you take medicine, it is 7 days. If you don't take medicine, it is 1 week. Sufficient rest is necessary. Since it is stated by the learned counsel, the learned proxy counsel, that the learned counsel for the petitioner is suffering from fever and would be recovering in about 2 weeks. Taking an extremely sympathetic view, the matter is adjourned to 28/11/2023.
Deeply obliged.
On the first date, after this amendment of the CRPC, it cannot be adjourned. It should not be, rather. It should not be adjourned. After we issue notice to the informant, they appear, they make their statement. Then what is the point in adjourning the matter when all the materials are on record? Yes.
Deeply obliged.
26. Intimation was given to the parties to file
M.S.Sahoo for the petitioner. Mr. Learned Counsel for the petitioner seeks further accommodation to file affidavit on behalf of the petitioner in terms of his submissions as recorded in order dated 28/7/2023 as prayed for. List on kebe chahuchanti?
2 weeks.
List on 30/11/2023 to grant further opportunity to the petitioner. By what date you can file the affidavit?
My lord, I will file an affidavit on 23rd.
Affidavit be filed in the meantime, copy be served to enable the Lord and State Council to obtain instruction. Yes.
27. My lord, on behalf of Mr. Jullu Khan Sama, I pray for an adjournment, my lord.
Your name, sir?
BP Mishra.
Mr. B.P. Mishra.
BP Mishra.
D.
Bibu Prasad Mishra.
So B. That is how.
Yes, my lord.
You better say the full name so that it. So Bibu Prasad Mishra for the for on behalf of J. Khansama for the petitioner. The Learned Counsel for the petitioner seeks accommodation. Prayer for adjournment is made on behalf of the Learned Counsel for the petitioner. As prayed for, list on 4th December 2023. You have received case diary. The Learned Standing Counsel submits that case diary is available. Yes.
28.
Mr. S.K. Patnaik for the petitioner. Mr. Standing Counsel for the state.
CD is not there.
It's not there. The Learned Counsel for the petitioner seeks accommodation to advance arguments as prayed for. List on 1st of December 2023. Further time due. Further time due to Mr. Bari. 12th of December 2023. The Learned Standing Counsel shall obtain up-to-date case ID. Yes.
29. May I please, your lords?
Yes. Rajiv Lochan Patnaik for the petitioner. Mr. Standing Counsel for the state.
My lord, the case is under section 363, 366, 376 2N of the Indian Penal Code, reduced section 6 of POCSO, my lord.
Here, no notice is required to be sent to the
notice 376 2 is there, my lord. And last occasion, your lordship had granted interim bail for a period of 1 month, my lord. After 1 month, my lord, he surrendered in time, your lordship. Today, I have filed the surrender certificate of the petitioner, your lordship.
You file it in the registry.
Since my lord, the victim was pregnant,
for offences under section 498, 304B, 306, 506 and 34 of IPC read with 4DP Act. My humble submission in the matter, my lord, and the autopsy report of the deceased, my lord, shows, my lord, my hope with the lordship's permission, my lord, that the deceased committed suicide. And my lord, the reason as it is reveals from the
306 Achita.
My lord.
So what is so big deal about that autopsy revealing suicide?
Suicide.
So then why 306? It's not a case of 302. It's a case of 306.
Yes. That's something.
Yes. Yes.
That is my submission.
Yes.
And
but you are arguing for the informant or for the petitioner?
No, I'm for the
sure.
Accused.
Sure, you are for the petitioner accused, not for the informant. Yes.
And
that he should have submitted that it is corroborated by the autopsy report that it's a case of 306.
306.
Yes.
But I'm scaling down that is a case of 306, and there is no direct allegation, or even if indirectly, that the husband, the present petitioner, who are instigating or abetting in any sense.
Instigation is ingredient, essential ingredient of 306.
306.
Essential ingredient.
Yes.
Husband, 1, 2, 3, 4. 4 persons will instigate a 5th person who will torture the victim to commit suicide. Is it necessary?
Not my humble submission.
It's not there. It's not there.
But allegation.
I'm really at times.
At time may not.
As far as the deceased is concerned, by the accused petitioner, the Learned Counsel for the Learned Standing Counsel also refers to the statements contained in the statements recorded under section 161 of the CRPC, disclosing the past incidents. Regarding the activity of the petitioner. Whole problem, Mr. Das, is that you don't understand. The more you delve into this, that there will be reflection on the merits of the case. Having heard the learned counsel for the petitioner, the learned standing counsel, this court is not inclined to grant bail to the petitioner at this stage. Accordingly, the petition is dismissed at this stage. Yes. Yes.
31.
Dismissed.
I am on behalf of Soumya Ranjan Das. Lordship, pray for adjournment item number 31 and 32.
Your name, sir?
Bikram Kumar Naik.
Mr. Bikram Kumar Naik on behalf of Soumya Ranjan Das for the petitioner. The learned counsel for the petitioner. Yet again, prays for adjournment. On 5/10/2023, adjournment was sought for on behalf by the learned counsel for the petitioner, and the following order was passed. To grant further opportunity to the petitioner, list on. When do you want or further time?
Sir, next week.
30/11/2023, the learned standing counsel reiterates his submissions that CD is available, case diary is available.
32.
Same, my lord.
Same FIR.
No.
No, my lord. Item number same. 31,
395.
I do.
Appearance saman rahibo.
Okay.
The learned counsel for the petitioner, yet again, adjournment is sought for on behalf of the learned counsel for the petitioner, though granted earlier. On 9/10/2023, after adjournment was sought for by the learned counsel for the petitioner, the following order was passed. The learned, in view of the prayer for adjournment, to grant further opportunity to the petitioner, list on 30/11/2023. You have obtained the up-to-date status of the cases. The learned standing counsel submits that he has received case diary. There is a direction that your affidavit is not in sync with whatever they are submitting. You have 14 past allegations of criminal activity. This particular petitioner Gojo or Goja. Yes.
33.
Mercy, I am seeking to pass over this matter.
To be called again at 2 p.m.
34.
For your lordship, I am praying for an adjournment because in fact in this case I have filed.
You are Mr. Lenka or Mr. S.S. Lenka?
No, my lord, Kaustuv Mahanti.
Mr. Kaustuv Mahanti for the petitioner. Mr. Standing counsel for the state. Learned counsel for the petitioner. 6 accommodation. Advance arguments. As paid for list on 1 December 2023 to grant further opportunity. The learned standing counsel reiterates his submissions that case diary is available, including the statement of the victim recorded under section 161 of the CRPC before her death. Yes.
35.
Item 35, lordship, I pray for an adjournment.
Mr. A. Sota for the petitioner. Mr. Standing counsel for the state. Learned counsel for the petitioner 6 accommodation to advance arguments. To grant further opportunity, list on the petitioner. For the opportunity to the petitioner, list on 5th of December 2023. The learned standing counsel submits that case diary is available. Yes, next.
36.
That's offense under section 399.
Yes.
402 and 25 of Arms Act and 34 of Explosive Substance Act.
The connected BL appeals are pending or disposed of. 8555, 8962, 8966.
In connection to co-accused must be.
Because in view of Pradhani Jani, if it is disposed of, this bench cannot take up.
Number of bail applications, my lord.
But verify, can you verify?
No,
Because my report is older one actually. I don't know. This is 4th of August.
That's for the noting, all are pending. All are pending.
Pending bole कोठु देखले कहले?
Noting in the cause list, my lord. BLAPL number 8555,
Noting pending
8966.
They have not been listed.
No, my lord.
noting is all are pending. I don't know the.
What are the orders passed? Then how to know that? Pending, but what is the order? I don't know.
No, in the list, my lord, it shows all are pending.
That I have followed. That is how I'm asking.
And let
After
all the bail application come together to be better for this result. Because other bail application has also been adjourned.
Mr. Vishnu Prasad Pradhan for the petitioner, Mr. Standing Counsel for the state. The FIR details match furnished by the registry indicates that BLAPL 8555 of 2023 into bracket Ritu Rana versus state BLAPL is pending arising out of the same FIR. In the cause list, it is indicated that out of the same FIR, BLAPL 8962 of 2023 and 8966 of 2023 are also pending. Registry shall verify if the other bail petitions, that is BLAPL 8555, 8962, 8966 are assigned to this bench or not. If the if the other bail petitions are assigned to this bench, steps be taken for listing of those matters along with the present matter. If if any of the bail petitions have been disposed of in the meantime, the steps be taken for listing of all the connected matters in terms of the two of that circular order. What is that, Mr. Na? Yes, two of it for listing of the matter. Yes. Next. If any matter has been disposed of, then it has to go to that bench. But most likely they are pending. Yes.
37.
Mr. Ponda. Date kebe karibe ithre? When do you want, Mr. Pradhan? Date?
Next week, any date was.
List on 28 kar diyantu. Because they have to search it. That has become a really difficult task.
I'll check it.
Yes.
Today I'm filing the affidavit.
You are Mr. Nanda.
Ponda, sir.
You are Mr. Satyanarayan Ponda. Mr. S.N. Ponda for the petitioner. Mr. Standing Counsel for the state. Learned Counsel for the petitioner submits that he is filing affidavit on behalf of the petitioner indicating the past allegations of criminal antecedents, if any. So, affidavit be taken on record, scanned copy be updated. Copy of the affidavit is served on the learned Standing Counsel to enable him to obtain instruction. List on how much time, Mr. Standing Counsel?
10 days.
Case diary is available.
Yes, ma'am.
As paid for, list on 30/11/2023. Yes. Yes, what you are saying anything?
No, sir. Affidavit today I filed with regards to anticipation.
Yes, filed. That will be taken on record. Scan copy to be updated. Copy served on the Standing Counsel who shall obtain instruction. Yes. Anything else?
No, sir.
Yes. Yes. Mr. Misra.
I pray for 1 week after filing. In this case, I will take instruction.
Mr. T.K. Misra Sukuna Kumar Misra for the petitioner, Mr. Standing Counsel for the State. The learned counsel for the petitioner seeks further accommodation to advance arguments. Para has prayed for list on
1 week after one.
Sorry?
1 week after one.
5th of December?
Obliged.
5th of December 2023. Mr. JP Pat, Mr. Vivekananda Bhuya. Vivekananda Bhuya, Special Counsel. Into bracket OPID along with J. P. Patra. Additional Standing Counsel. Additional Standing Counsel.
Obliged.
Yes.
Can be adjournment.
Mr. S.K. Patnaik for the petitioner, Mr. Standing Counsel for the State. Last matter is Standing Counsel to the change call it. Did B. Bhuya special. Yes.
39.
S.K. Patnaik for the petitioner. Mr. Standing Counsel for the State. Learned Counsel for the petitioner seeks further accommodation to advance argument. You have received copy of that flag B.
Blood. Item 39, madam.
For 11 years, there is an allegation that he has managed.
Actually, he was in jail custody. Thereafter, malad, after some, your lordship may see that letter, madam. Kindly see that letter.
You are referring to letter dated?
That 510 letter, madam.
No, 510 letter. I wanted to, through your investigating agency to verify whether it is a fact. If he's in jail custody, then he could not have evaded arrest.
No, my lord. Your lordship may see the para 6, my lord.
Yes.
Actually, he was absconded for after release in that case, my lord. As it seems for the letter, I have, my lord, examined that letter. After being released in that case, my lord, he was absconded for certain time. For that,
So,
my lord,
Patnaik, you better prepare that chat.
because your lordship
In
may
how
see,
many cases where he was arrested and where the case is pending?
he has voluntarily surrendered before the, my lord, court below, my lord.
So that
That means
that
he was
shows that
outside.
he may not be aware, Mr. The problem is that he may not be aware that he is wanted in so many cases. Because you see, the one may be wanted in 10 cases, arrested in 1 case.
Yes.
Regarding rest 9 cases, he is not aware. But you can very well say that he is evading arrest in 9 cases. And can you say that? Because he is already in custody.
But on
Because he doesn't understand. A person of his level of understanding or education, he can't understand that
his submission was that
his presence in other proceeding has to be done by the legal aid or by somebody or by his own counsel.
his submission was that he was there in the custody. NBW should not have been issued. My lord, here, as per para 6, my lord, he was there in outside, my lord. After release on bail.
So he has surrendered.
He has not. After some days, he has surrendered. Actually,
After issuance of fresh NBW, he has surrendered.
Surrendered, my
On
lord.
the 2nd of May.
Not in time. After issuance of NBW, that means that, my lord, all the date chart have to be, my lord, let him file a date chart. From
No, that is not doing. That is not doing. He's adjourning for last 2 occasions.
Because, my lord, he has surrendered. My lord, as it seems from para 3.
You see,
He was in custody.
He must be represented by some counsel in all cases.
Yes, sir.
Some counsel doesn't take step. NBW is issued. So how does he know? But he was arrested in some cases. So his arrest qua a particular case is not known to him. He doesn't realize that.
And it has to be seen from his my lord.
But explain karantu. Make some effort. Again? ନିଅନ୍ତୁ ଆପଣ ସେ କପି ଦେଇପାରିବେନି because it's a letter from the judge to the High Court. ଆପଣ ସେ ଡିଟେଲ ଗୁଡାକ ଟିପିକି ନେଇ ଯାଆନ୍ତୁ. ସେ କେମିତି ଦେଇଦେବେ ସେଟାକୁ? It has been sent to him by email to from the registry. कौन लिखले? When do you want, Mr. Patnaik?
6th December.
6th of December.
Well,
as prayed for list on 6/12/2023 to grant further opportunity to the petitioner. Yes, case there is available.
To file a date check. That will be my lord.
He will not do that. Because the learned counsel or the petitioner shall prepare a date chart indicating all the cases.
A period of custody.
In different cases. Date of release. And status of trial in all the cases. You allow him to peruse that letter.
Yes, I'll do. Certainly.
Yes.
Otherwise.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, dispute between two brothers due to some civil properties, Your Lordship.
Yes.
Allegation against this present petitioner is that he, along with 7 others, accompanied with the elder brother, though those have assaulted the younger brother, Your Lordship.
No other criminal incident you have filed served copy. What is your instruction, Mr. Standing Counsel?
My lord, regarding criminal answer, they have not given it, my lord, Your Lordship.
No answer, I have given that.
They are not reported.
Another copy.
In the city, this is not reported. Regarding health condition, informant is the, my lord, complainant is himself is the injured, and the 161 statement recorded, and the, my lord, although injury is grievous, my lord.
He has recovered Mr. R.R. Rohit Ranjan Rai for the petitioner, R.R.Ray. Mr. Standing Counsel for the State, Learned Counsel for the State submits that he has received instructions in terms of the earlier order dated 2/11/2023 regarding health condition of the injured victim, who is also the informant, to be stable, and he has been discharged after treatment, and his statement has been recorded. The Learned Counsel for the petitioner submits that he has filed affidavit on behalf of the petitioner through his wife dated 8/11/2023 indicating that the petitioner has no other past allegations against him as far as criminal activity is concerned. It is submitted by the Learned Counsel for the petitioner. First paragraph pore apana arambha karchandi 2 ru the petition has been filed so and so, put lekhibe paragraph, then 2, then 3, that tapare lekhibe kon lekhile that the petitioner is in custody since
custody since 22/7/2023.
22/7/2023. The alleged occurrence out of which the present case arises is a dispute which is civil in nature between brothers, and the petitioner should be shown indulgence as far as prayer for bail is concerned. Stop. It is further submitted that the petitioner, being a local person,
yes,
having roots in the society, there is no possibility of he escaping the jurisdiction of the learned court in season, and the petitioner shall abide by all such terms and conditions that would be imposed for grant of bail. Having heard the learned, submission further. The learned Standing Counsel, referring to the materials contained in the case diary submitted by the investigating agency and the nature of allegations, opposes the prayer for bail. However, it is not disputed However, it is submitted that as per the case diary furnished by the investigating agency, there is no past criminal allegations of criminal activity against the petitioner. Having heard the learned counsel for the petitioner and the learned standing counsel for the state, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, which shall also include a condition that any violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing of petition for cancellation of bail by the informant oblique victim oblique law enforcement agency, disposed of accordingly. You make them aware.
Yes, Your Lordship.
Because it's a harsh condition.
Yes,
but considering the nature of, because there is a possibility that after coming out they may indulge in this kind of activity because of the proximity of the what?
The petitioner.
With whom?
With the complainant.
Yes. Yes, next.
Much grateful, Lord.
41.
Your Lordship, on behalf of Mr. Jali, kindly take
Mr. Tripathi, Mr. J.P. Tripathi. You are Mr. Tripathi, J.P. Tripathi.
Yes.
Mr. J.P. Tripathi for the petitioner. Mr. Standing Counsel for the state. Learned Counsel for the petitioner seeks accommodation to advance argument as prayed for list on 6/12/2023 to grant further opportunity to the petitioner. Health condition asilegi?
The up-to-date city health concern ani.
Asini. The learned standing counsel shall obtain the up-to-date case diary as well as instruction regarding the health condition of the injured victim. Yes.
42.
Mr. Deepak Kumar Mahapatra for the petitioner, Mr. Standing Counsel for the state. Affidavit copy served.
Copy served. Affidavit filed.
Copy kahin na.
120 grams.
147 grams.
Say 120, 47.
Lordship.
Affidavit
Yes.
copy.
हाँ दे दीजिए. सर्व इसे है कि फाइल लीजिए कोर्ट.
Kahin.
10 तारीख को फाइल है. 10 एक दे देते.
The learned counsel for the petitioner submits that he has served copy of the affidavit filed on behalf of the petitioner through his brother on the learned counsel for the state, indicating that there is no other criminal antecedents against the petitioner.
No. The answer is there. No. That's why I don't have the copy of the affidavit.
Or likely?
There are 3 answers.
The learned standing counsel submits that as per the instruction received from the investigating agency, there are past allegations of criminal activity on 3 occasions against the petitioner. The learned counsel for the petitioner seeks accommodation to file further affidavit. By what time you can file the affidavit?
By next week, Lordship.
Let the affidavit be filed. As undertaken, for that time, prayer is allowed, affidavit be filed by 24. 24/11. By 24/11 or earlier you can file.
Earlier you can file.
By 20/11, copy be served on the learned standing counsel. List on, when do you want? 29. 29/11/2023. Learned standing counsel submits that case there is available.
Yes.
Yes.
43.
Without verifying, don't file affidavit.
So brothers,
No,
again and again.
Manoj Patnaik. Of Manoj Patnaik for petitioner, Mr. Standing Counsel.
Extra copy not filed.
For the state, Mr. Patnaik, you have not filed any copy in the registry?
Sir, file kar deej, sir.
Then why there is a noting? Who is there in the VC room?
Samat अनुमति देले मु स्क्रीन शेयर टा देखे दी.
Yes. Mr. A, so there is a noting that he has not filed copy in the registry. Has he filed?
See, he has uploaded the file on 18/10/2023, Lordship. But what I checked in morning, it is not showing, Lordship. Due to some
So you inform him. You inform him. Because these technicalities are little bit, you have to make aware the learned counsel, make aware. Mr. Patnaik, you have heard him. He is unable to find that being uploaded in the website or in our system of the registry of the court. এটা কেতে নম্বর মিস্টার মনোজ পটনায়ক লিখিলে হাইব্রিড মোড লিখিলে Mr. The learned counsel for the petitioner being present at the virtual court, Odisha High Court at Berhampur addresses arguments. Mr. ASO, I am recording that he will submit it again. The addresses arguments. You have received copy, Mr.
We have downloaded it from the
Downloaded and forwarded.
Our High Court to direct.
Okay.
So copy dele would have.
Yes, Mr. ASO. Did you hear Mr. Standing Counsel? Then if it is available in the website, then for you forwarding it to the concerned court in season of the matter is not a problem. Simply forward that.
Lordship, today morning also I have uploaded the file before registry, Lordship.
Yes.
Sir, I am seeing the file. The same file is to be sent to the court in season of the matter.
Lordship.
So no need for again, actually. Digitization has this advantage. Once it is available for all the time. Yes. The learned counsel, Mr. Patnaik, for the petitioner submits that he has he has uploaded the extra copy on 10th of the date, Mr. Patnaik?
No, 10
after the order. In terms of the order dated 9/10/2023, 9/10 order pare kebe file kale?
8/10 रे कली सर.
On 18/10/2023, in terms of the earlier order dated 9/10/2023. The registry shall do well to forward the copy of the petition by email to the learned court in season of the matter, along with copy of the order dated 9/10/2023. Para. The learned court in season of the matter shall do well to intimate the informant oblique victim through its office regarding the right of audience in the present proceeding and the next date of proceeding.
Not recorded.
Para. As indicated in the order dated 9/10/2023, legal aid shall be provided to the petitioner, not the petitioner, to the informant oblique victim, if they are unable to engage any counsel on their own. List on 1st of December 2023. The next date of listing shall be intimated to the informant oblique victim. Whenever Mr. ASO, could you follow what I am saying?
Sir.
Since it is already available, the next copy is not necessary even. You can simply forward it. Yes.
Item 44.
Yeah, please, my lord. Pursuant to your lordship's order,
Mr.
my lord,
P.K.
I
Ponda.
filed the affidavit, my lord.
Mr. P.K. Ponda for the petitioner. Mr. Standing Counsel for the state. You have sought copy.
Yes, my lord, I have sought
Well, I have been directed, my lord, to take operate CD and the response to the affidavit that I will take, my lord. We have
Not yet received. Mr. P.K. Ponda for the petitioner. Mr. Standing Counsel for the state. The learned counsel for the petitioner submits that he has already sought copy of the affidavit filed on behalf of the petitioner, dated 9/10/2023. The learned standing counsel seeks further accommodation to obtain response to the said affidavit as well as the up-to-date case diary. How much time, Mr. Standing Counsel?
10 days.
As spread for list on 28/11/2023. Yes.
Let it be done 30th, my lord. 28th amended.
30th.
Yes, my lord. 28th amended be available, my lord.
30/11/2023.
Obliged, my lord.
Yes.
45.
Mr. R.R. Rai for the petitioner. Rohit Ranjan Rai for the petitioner. Mr. Standing Counsel for the state. Yes.
Your Lordship, we have recently engaged by virtue of the prisoner petition. We need some time.
The learned counsel for the petitioner seeks further accommodation
My
to
friend has
advance arguments.
filed an affidavit stating the criminal incident numbering 7, my lord. As per my record, my lord, it is
I will
15
correct
criminal
that.
incident.
15.
Yes, yes, I will correct that. The
Correct,
learned
up to
counsel
earlier
for the
counsel
petitioner
have filed
submits.
that.
What likely? Yes. Para. It is submitted by the learned counsel for the petitioner that the copy of the affidavit has filed on behalf of the petitioner sees the mother through his mother has been served on the learned standing counsel. However, the petitioner, the learned counsel submits that he may be permitted to file further affidavit indicating the past allegations of criminal activity against the petitioner. Prayer is allowed. Let the affidavit be filed. How much time, Mr. Rai?
2 weeks. Your Lordship.
Affidavit be filed by 29/11/2023. Copy be served on the learned standing counsel to enable him to obtain instruction. List on 8th of December 2023.
Grateful, Your Lordship. Much grateful.
Yes, next.
46.
At 46, my lord, as per Lordship direction, my lord, already filed the affidavit.
Mr. S.K. Patnaik for the petitioner. You are Mr. Patnaik. Mr. S.K. Patnaik for the petitioner. Mr. Standing counsel for the state.
The copy of the affidavit.
The learned counsel for the petitioner submits that he has filed affidavit on behalf of the petitioner.
Copy not, sir.
To the father of the petitioner, indicating the past allegations of criminal activity against the petitioner, comma, if any. If any, stop. Copy of the affidavit shall be served on the learned standing counsel during course of the day.
My lord.
During course of the day to enable him to obtain instruction. As prayed for, list on 1/12/2023. You also take instruction that some family member of the petitioner should be standing surety
Because
and one local surety.
petitioner is from Bihar.
So that you have to ensure.
My lord.
But after filing of the petition, you are not doing. I mean, in most of the cases, for 4 months, 5 months, it is just kept pending. You have case diary.
Yes.
The learned standing counsel submits that the learned standing counsel shall obtain up-to-date case diary. Yes, next.
47.
It will not press, madam.
Mr. Biswaranjan Dalai for the petitioner.
Thank you.
Mr. Standing counsel for the state, the learned counsel for the petitioner submits that as per the instructions from the petitioner doesn't want to pursue the present petition. Memo dated 14/11/2023 filed on behalf of the petitioner is taken on record. The petition stands dismissed. Yes.
48.
Pray for adjournment.
Sorry, sir.
Pray for adjournment.
Your name, sir?
Sarath Kumar Jena.
Mr. Sarath Kumar Jena for the petitioner. You are for the informant.
My lord, I'm victim for
Mr.
Deepak Kumar Pandit.
Standing counsel
Today I
for
have
the state.
Today I filed my vocal.
Mr. Your name, sir? Kindly
Deepak Kumar
Mr. Deepak Kumar
Ponda.
Ponda for the informant, oblique victim. The learned counsel for the petitioner seeks accommodation to advance arguments. Stop, Sapara, to grant further opportunity. List on 5th of December 2023. What do you say? You are opposing the prayer for the bail.
My lord, I am opposing.
The learned standing counsel submits that case diary is available along with the statement of the victim recorded under section 164 of the CRPC. The learned counsel for the informant oblique victim opposes the prayer for bail. Yes. Date call choti to. Date call pore. Yes. Rest of the matters after recess. Yes.
Submission, my lords.
Yes.
Item number 61, 62,
Yes, please.
and 68, my lords. My lords, I pray
61.
61, 62, and 68.
Yes.
The lordship record may be permitted to be seen, my lords, during the lunch hour, so they can assist your
My lord,
lordship.
yes, they may be going for the lunch, no problem. Even after lunch hour, you can. Upon day period,
Only two fights.
My lord, 49, my lord.
61, 62, 68.
61, 62, 68.
Just get the physical record.
My lord, 49.
Yes, 49.
Next week, some file tag thila ki nahi ଯାଇଛି file file order misplace ହେଇଯାଇଛି.
SK Jenna.
Next week ro.
23rd.
21 ho.
22nd କହୁଛନ୍ତି.
Yes, madam.
22nd ଠିକ ଅଛି. Yes.
My lord, item 59.
59.
On behalf of Sunil Kumar Panda, permitted to withdraw.
Your name, sir?
SK Pollai.
Memo?
I'll give you.
Memo ଦିଅନ୍ତୁ, sir.
Yes, ma'am.
Yes. 59 କହିଲେ ତ?
Yes, ma'am.
Yes. Be careful, the wrong record will be wrong order will be passed. Yes. Yes.
That parallel item 52, lordship. 2 chapter, lordship.
But after I see the order sheet, then I will pass.
Lordship, there is a direction to file the comprehensive affidavit. Because
Oh, affidavit not filed. Sir,
Not-
କହିବେ that you are seeking time.
Lordship.
Date କରନ୍ତୁ 52. 6/12. 6/12.
Lordship.
51 2 chapter. Item 51.
51. You are Mr. Das.
My lord.
There is any order to be affidavit?
No, no, my lord.
I'll see the order sheet, then I'll pass the order. Tentatively date କରିଥାନ୍ତୁ 51.
My lord,
7 December.
item
Mr. Das.
Last occasion non appears ହେଇଥିଲା ତେଣୁ
Whatever.
item 46 date was not fixed, my lords. Item 46.
Date ହେଇଥିଲା ନା ମୁଁ ପଚାରିଲି ତାଙ୍କୁ. Date କରିନାହାନ୍ତି? I think 1st of December, or you want further time?
My lord, what happened, my lord? Similar 3 matter, my lord, pending before lordship, that was posted tomorrow, my lords. Similar 3 matters.
Which matter this is?
That out of same affair, 3 others matter, my lord. That in the list also that is mentioned, that number mentioned 46. And that was, my lord, posted tomorrow, my lords.
So you note the date. ସେଟା ବି ଏକ ବାରରେ ଆସିବ.
My lord, item 79. Here, my lords,
79.
79, no instruction.
Memo ଦିଅନ୍ତୁ.
Ma'am, I will
But I'll pass the order after looking at the brief.
Okay.
No, 57, my lord. 57.
Just a second. 57, sir?
Yes, my lord. Some defect is there. I press some time to remove the defect, my lord.
2 weeks.
Yes, after 2 weeks.
Mr. B. Mahapatra.
Yes, my lord. After 2 weeks, I will remove.
Yes. Next.
My lord, 31st ରେ ଥିଲା।
List above removal of defect. Yes. I'm not giving a specific date because I don't know the exact list. Sorry? Bola?
sir 30 ରେ ଲିଷ୍ଟ ଥିଲା କିନ୍ତୁ ଲିଷ୍ଟ ହେଇନି sir କେବେ ଆସିବ sir 31st ରେ 30 ରେ ଥିଲା
ମେମୋଟା କହୁଛନ୍ତି ମାନେ ଗୋଟେ ମ୍ୟାଟର ଆପଣ ମେନସନ କରୁଥିଲେ
sir ମୋ 30 ରେ ଥିଲା ତାପରେ ଆଉ ଲିଷ୍ଟ ରେ ଆସିନି
ନାଇଁ ସେଟା ବେଳେବେଳେ ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ କରିବାକୁ ପଡୁଛି ବେଶୀ ହେଇଗଲେ ଆପଣ ଟିକେ ଲେଖି ଗୋଟେ କାଗଜରେ ଦିଅନ୍ତୁ Mr. Barik will look into it. When it was posted to be listed on 30th of
yes my lord
just give it in give or a memo or a paper likhi diyontu. Yes, after recess rest of the voice over. Once when the matter is before the once when the Matter was called at the first instance. And again after break. The petition was filed in the year 2013 under section 401 and 397 of the CRPC. Challenging the order passed by the STJM Campus, taking cognizance of the matter corresponding to Panpos PS case number so and so, PS case corresponding to Hattobari PS case number 38 of 2008, corresponding to GR number 1373 of 2008. Para. On perusal of the available order sheets, on perusal of the order sheets, not available, order sheets, it is indicated that the after continuation of delay, the matter has not been admitted. Though listed on several occasions and adjourned by the learned counsel for the petitioner. Since the challenge was at the stage of cognizance, taking of cognizance, at the stage of taking of cognizance by the learned court of the first instance, and there has been no interim order, nothing would survive at present for adjudication before this court. Learned additional government advocate referring to the order impugned submits that nothing survives at present after the passage of 10 years, after a lapse of 10 years.
Item 13.
30, sir.
13.
13. None appears for the petitioner, though the matter is called twice over. Complete the entire paragraph. Mr. 13, Mr. Naik. Petitioner none, Mr. Devasis Naik AG for the state. So, जोटा आराटा भी से है, जोटा dispose of है ना, सेटा भी non petitioner none, Mr. Devasis Naik. None appears for the petitioner when the matter is called the earlier occasion on 1/11/2023, 17/10/2023, 5/10/2023, 25/8/2023. None had appeared for the petitioner. And the matter was adjourned to grant further opportunity to the petitioner. Subpara, in considered opinion of this court, sufficient indulgence has been shown to the petitioner. Apparently, the petitioner doesn't want to prosecute the matter. Stop, para. The petition stands disposed of. Yes, next.
13.
Petitioner on Mr. Devasis Naik KGA for the state. Same order as in 13. Yes.
This was dismissed.
Item 33.
Disposed of.
My lord.
Dismissal order because in absence of, it can be dismissed actually.
My lord.
May I please, my lords, item 33.
Yes.
Allegations under section 307 along with other offences, my lord.
Yes.
Your lordships has been pleased to grant interim bail to the present petitioner, and in the meantime, my lord, he has surrendered in due time. I am just submitting that order.
You also serve the copy of the surrender certificate on the learned standing council. You are Mr. Patra.
Fine.
You don't have power here?
I don't. My lord.
Mr. Patra, you are not having power here?
Yes, my lord. I am on behalf of Mr. Hon'Ble Das, my lord.
Your name, sir? D. Patra.
DK Dinesh Kumar Patra, my lord.
DK Patra.
My lord.
DK Patra, दे देवे रजिस्टर फाइल करिए. Mr. Patra, on behalf of Anupam Das for the petitioner, Mr. Standing Counsel for the state, and counsel for the petitioner submits that after the expiry of period for interim bail, the petitioner has surrendered on.
Yes, surrendered on 10/11.
10/11/2023.
Yes, ma'am.
This is that Baleshwar matter.
My lord.
That question leak matter.
No, my lord. It's an allegation under 307.
Okay.
In fact, case and counter case.
So what are the past allegations against
allegations, my lord? Both the petitioner.
Past allegations.
Past allegations, both the present petitioner
Is
and
there criminal incident?
no criminal incident. In fact, he is a student.
What is your instruction?
My lord, my CD says that they have not reported any criminal incident. That means not there.
And my lord, so far as my instruction is concerned, he has recovered in the meantime also. Both are cousin brothers, the petitioner and
person sustained injury, one having grievous injury, one having simple, and their statements has been recorded under 161.
Charge sheet has also been filed.
That means they are.
Okay. Certificate. Nikhil. Before the learned JMFC, Purushothampur, and has been forwarded to jail custody. The learned counsel for the petitioner submits that the petitioner is in was in custody from
3/7/2023, ma'am.
3/7/2023.
Yes, ma'am.
Till
the date of surrender and thereafter also.
Interim bail के बेला.
Interim bail was granted by this Hon'Ble Court on 12/10.
केबे गले sir. Custody मु पचारुची. 3/7/2023 to 12/10/2023.
Again. Thereafter 10/11 surrender.
And again has been remanded to jail custody on 10/11/2023 after the period of interim bail granted by this court. It is submitted by the learned counsel for the petitioner that considering the nature of allegation against the petitioner and the fact that the alleged incidents occurred due to interstate dispute between two cousin brothers, the petitioner may be shown indulgence as far as prayer for bail is concerned. It is submitted that the petitioner being a local person having roots in the society, there is no possibility of he escaping the jurisdiction of the court in season of the matter. And the petitioner shall abide by all such terms and conditions that would be imposed for grant of bail. Is submitted the standing counsel referring to the case diary and materials in the case diary submits opposes the prayer for bail. Here you have filed affidavit or mentioning that there is no criminal incident.
On instruction, not.
The learned counsel for the petitioner submits that he has, as per his instructions, the petitioner has no prior past allegations against him as far as criminal he has no past allegations against him criminal in nature. Stop. The learned standing counsel submits that as per the case diary submitted by the investigating agency, no past allegations against the petitioners have been indicated, has been reported. Para. Having heard learned counsel for the petitioner, the learned standing counsel, and considering the material on record, the court is inclined to grant bail to the petitioner on such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition that in case of violation of any of the terms and conditions, violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail, in case of the kati diuntu, in case of what the kati diuntu, but yeah, condition that violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing of petition for cancellation of bail by the informant oblique victim oblique law enforcement agency, disposed of accordingly. Mr. Suresh Kumar Jena for the petitioner, Mr. S.S. Mahapatra AC for the state. Learned counsel for the petitioner submits that he may be accommodated as his case brief has been misplaced. The learned additional standing counsel submits that you have received the up-to-date case diary. And injury report is there. Present health condition is there. Okay. Just the microphone is switched on or switched off?
Sorry, my lord.
Yes.
My lord, I have already discussed with the IAC. He will be sending by 2 days.
Okay. As prayed for Ago Lekhunta, as prayed for list on 22/11/2023.
Lordship directed.
The learned AC shall obtain up-to-date case diary, oblique status of investigation, oblique instruction, as well as health condition of the injured victim. Yes.
Item 50.
Lordship 22nd.
Yes, 22nd. It was actually mentioned before the lunch break.
My lord.
Yes.
Pray for 1 week, my lord.
Miss M.S.S. Senapati for the petitioner. Mr. S.S. Mahapatra AC for the state. Learned counsel for the petitioner seeks further accommodation to advance arguments as prayed for list on 30/11/2023. The learned AC submits that case diary is available. Yes, next.
51.
On behalf of SP Das, can taken a 1 week after.
Your name, sir?
D. Sethi.
Mr. D. Sethi, on behalf of SP Das for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. Learned counsel for the petitioner seeks accommodation. And Kati Lekhuntu, the prayer for adjournment is made on behalf of the learned counsel for the petitioner. As prayed for list on. This is which item?
Item 51, my lords.
As prayed for list on 7/12. It was mentioned 7/12/2023 to grant further opportunity to the petitioner. What is defect number 6? Copy state has received copy.
Yes.
The learned additional standing counsel submits that he has received copy. Copy. Therefore, the defect number 6 pointed by the staff report shall be ignored. Shall be treated to be complied with. Date kale Yeah. The learned AC submits that he has received the up-to-date case diary.
Yes, sir.
Yes.
52,
Mr. Santosh Kumar Mahanti for the petitioner. Mr. S.S. Mahapatra, AC for the state. The learned counsel for the petitioner seeks further accommodation to file affidavit in terms of the earlier order dated 13.09.2023 regarding past allegations, if any, against the petitioner. As prayed for, list on 6/12/2023 to grant another opportunity to the petitioner. Up-to-date case diary is there. The learned AC shall obtain up-to-date case diary, oblique instructions in the matter. Yes, next.
53,
Yes, please.
and this is option 341, 294, 320.
Kindly just adjust the microphone to your, yes, just further, bend it further below. Yes.
Offense number 341, 294, 323, 324, 320.
You have received health condition, a report regarding health condition of the injured victim.
Yes, my lord. I have received this. Okay. Just now, my lord.
You are Mr. Sahoo or Mr. Das?
Sahoo, my lord.
Mr. D. Sahoo for the petitioner, Mr. S.S. Mahapatra, additional standing counsel for the state.
He is also having one criminal antecedent, my lord. Whether my blonde friend is
Having one.
He submits that no criminal antecedent.
Last of wrongly I have mentioned, but one criminal antecedent is there, my lord.
What is the nature of allegation?
That
380, my lord. Offense number
380. In this case, my lord, a street vendor of petty chona अंडा बिक्री करले ताको तुरा से खाया मागिले से देलानी बोले कि assaulted by sword to his head.
ବର୍ତ୍ତମାନ କଣ କରିବେ?
And also he is having
ବର୍ତ୍ତମାନ ତ ଖାଇବାକୁ ମିଳୁଥିବ, ସରକାରୀ ଖାଇବା ମିଳୁଛି। କଣ ଲେଖିଲେ? The learned counsel for the petitioner submits that inadvertently he has mentioned that petitioner has no criminal antecedents. However, his statement may be corrected to the extent that the petitioner has one earlier allegation against him involving criminal activity. It is submitted that the petitioner is in custody since
19/8 2023.
19/8/2023. Final prosecution report submitted on
charge sheet submitted, my lord, on 31st August.
The final prosecution report has been submitted on 31/8/2023.
He was absconding. For that, it is being delayed, my lord.
Yes. It is submitted. The petitioner may be shown indulgence as far as prayer for bail is concerned. Stop. It is further submitted that the petitioner is a local person.
Yes, ma'am.
Is a local person having roots in the society, and he shall subject himself to the jurisdiction of the learned court in session of the matter, and shall abide by all terms and conditions that would be imposed for grant of bail. The learned additional standing counsel, referring to the past allegation against the petitioner, the allegations contained in the present FIR, as well as the fact that the petitioner once absconded. The petitioner absconded for some time before being arrested in the present case, opposes the prayer for bail.
And also having one criminal antecedent.
Yes. Having heard learned counsel for the petitioner, the learned additional standing counsel, and considering the material on record, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition that any deviation from oblique violation of any of the terms and conditions shall result in filing of petition for cancellation of bail by the informant oblique victim oblique law enforcement agency.
Pardon to mention one correct maybe district name wrongly typed Sonpur, my lord.
So the ago koithante first line likhibe opening sentence. The Lord Counsel for the petitioner submits that some inadvertent typographical error has crept in the petition and he may be permitted to correct the same. Prayer is allowed. The petitioner is permitted to correct the typographical error by supported by his signature. For a sign karibe because it is not possible without being. Yes, next.
Item 54.
Petitioner none. To grant for opposite party blank. None appears for the petitioner when the matter is called. To grant further opportunity, list on 12th of December 2023.
55.
Mr. K. Behera, Khogeshwar Behera on behalf of Aniruddha Das. K. Behera on behalf of A. Das for the petitioner. Mr. S.S. Mahapatra AC for the state. Learned Counsel for the petitioner seeks adjournment on behalf of the Learned Counsel for the petitioner is sought for. As prayed for, list on 14/12/2023 to grant further opportunity to the petitioner. Yes, next.
56.
Petitioner none. Opposite party, Mr. S.S. Mahapatra AC. None appears for the petitioner. When the matter is called, to grant further opportunity, list on 11/12/2023. Defect be removed. Defects as pointed by the SRs be removed in the meantime. Yes, next.
57.
Mr. B. Mahapatra for the petitioner. Opposite party blank. None appears for the petitioner when the matter is and the Learned Counsel for the petitioner seeks accommodation to remove the defects. Prayer is allowed. Let defects be removed as pointed by the SR within 2 weeks. Yes, next.
58.
Yes.
Worship kindly taken after 2 weeks.
Your name, sir?
Devi Prasad Rai Chaudhary.
Devi Prasad Rai Chaudhary.
On behalf
Mr.
of
D.P. Rai Chaudhary on behalf of Devi Prasad Dhala. You cannot appear on his behalf. He is a senior counsel.
Yes, ma'am.
So, on behalf of S. Mahapatra, S. Mahapatra for the petitioner, the Learned Counsel for the petitioner submits that due to inadvertence, requisites for issuance of notice on opposite party number 1 could not be filed. It is further submitted that time may be granted to file the requisites for issuance of notice on opposite party number 1. Prayer is allowed. Let requisites for issuance of notice be filed within 2 weeks for issuance of notice to opposite party number 1 in terms of the earlier order. Yes. You have to remove that. You have to file those requisites. Take steps. Yes. Next.
59.
Not 59. That will come 2 weeks after, my lord. I have taken instruction.
Mr. Palai has withdrawn it.
My lord?
They have withdrawn it. Actually.
No, my lord. I have the power, my lord.
No. He has already filed a memo.
No, I don't.
You are in 59 or which matter?
Around 59. Revision 415.
Is there? Yes, we done. Standing counsel for the state. Learned Counsel for the petitioner seeks accommodation to advance arguments as spread for list on 13/12/2023.
61.
There is an defect.
61. You mentioned you perused the.
No, I've gone through the minutes. Can be disposed of not. But in item 15, the Jugal Ponda's case, there's a defect number 9. Can be
Mr.
removed.
Dangri, please kindly remove the defect. Whenever you are holding any brief, sir, just go through the list. Always. Sangram Das, senior standing counsel for the state.
Lordship permits me not by submit one.
Yes.
Item 61. Today is listed for orders in the matter of condonation of delay.
Yes.
Notice has been issued
Yes.
And the registry has indicated that valid service on the opposite parties. Today is for final orders in the matter of limitation. And
Miss case 22 of 2014.
And if a lordship
As per the noting office note put up by the registry,
valid service
dated date ta padini
right side left right side
date
below.
pokenan dated 19/9/2018. Notice has been sufficient on the opposite party.
And today is listed
As far as the delay, as per the miscase, praying for condonation of delay.
Minutes may submit minutes.
Issue notice on admission. I'm issuing notice on admission. Let us take another notice.
Milord, why say so minutes? Milord, this is an application for condonation of delay.
If I'm allowing it, again I have to hear it for the admission. So like a civil matter, we are issuing notice for admission notice. Admission hearing notice is issued. So that is a better method, even in case of writ petition also. If it is condoned, suppose, I mean, in this LP also.
I'm not pressing hard so for the condonation person. The reason being, if a lordship can have a glance of flag A, my lords. Flag A. In a case of disproportionate case, my lord.
Here actually, condonation has to be permitted because he's not opposing it. Notice is sufficient. So at least in his presence, that order can be passed.
But if he's not turning up and say that,
then you after the delay is condoned, you take notice on admission. Admission to the opposite party in its present correct address. Requisites for issuance of notice be filed by registered post with AD. 3 weeks. Within 3 weeks, list after SR. You see, once the Learned Council cooperate, then it becomes so easier. But they are not appearing in most of the matters. And coincidentally, in 3-4 matters yesterday they appeared. Yes.
62.
Sorry. List after SR. The registry shall also verify if any Learned Council has appeared on behalf of the opposite party. Yes.
From item number 62.
Yes.
Up to 67.
Yes.
Now, all those matters pertains to the vigilance petitions for seeking leave of lordship notes. In all those matters, the registry has indicated requisites in all cases. From 62.
Here, Miss Dei has already appeared.
Here for instruction, no copy has not been.
No. Today is listed for filing of requisites.
She has appeared on advance notice. I mean, she appears on waves of notice. State can be said advance notice. 62, Mr. Sangram Das, Standing Counsel Vigilance for the State. The office note put up by the registry, dated so and so, at a miscase likhiye. Miscase 24 of 2014. Case likhiye na? Yes, 24 of 2014. The office note put up by the registry indicates that the postal requisites for issuance of notice on limitation has not been filed. That office note likhibe 8/12/2020 kete eta 12 kon agya apon to कहउचंती 8/12/2000.
But in the meantime, your lordship permits, my lord, the earlier case, that is 61, your lordship issue notice in the admission.
22. Office note dated 2022 that requisites for issuance of notice by registered post with AD had not filed. In the subpara, however, Ms. Anima Kumari Dei submits that he has instructions to appear, has filed wakalatnama and waves of notice. Notice shall be treated to be sufficient on the opposite party. the petitioner state shall serve an extra copy of the petition
Yes, sir.
along with enclosures on the learned counsel appearing for the opposite party. Yes.
If your lordship permits more, if your lordship go to the item number 63, the 61, I'm afraid your lordship is correct in sending the notices in the admission matter, item 61. Most likely the accused, my lords, he was the PET of 61, my lords.
Yes.
PET of Revensa College is no more, I think, my lords. That's what-
Radhananda. Yes. It's my college also.
Anyway, if the notice in admission goes
No, no, the problem is that again it will be insufficient.
notice padela admission re reports that no more like this. Or I'll take instruction. I believe
Better you take instruction because today it can be closed. I mean, you'll remove the defect.
63 to 67, I pray for some time to file the requisites.
2 weeks or 3 weeks.
3 weeks.
Mr.
No. In fact, item number 68, my lord, notice to go, my lords. 68 is requisite to be filed, my lords. Same ordinary possible.
I'm so sorry. I was switched off. Inadvertence for 8 years. Then 64.
65.
65 also, I pray for.
Not filed.
No.
Same order. But kindly check the office note. Yes. 65 same. 66 not filed. 67 not filed.
No.
68.
68 will let notice go, notes.
Miss case. 66 of 2014. Miss case 66 of 2014. The miss case has been filed for condoning the delay in filing the petition. Delay of lekhibe, specify karibe. Delay of 3 years and 339 days. Hard learned standing counsel issue notice. Let requisites be filed for issuance of notice by registered post with AD within 3 weeks. List after SR.
69.
Private package.
Petitioner none, Mr. Additional Standing Counsel, S.S. Mahapatra, Additional Standing Counsel for the state. None appears for the petitioner when the matter is called. To grant further opportunity, list on 12/2023. But here, Mr. Mahapatra, 23/4/2015 notice issued. Not filed, requisites. 23/7/2015, again time granted. Not filed.
Sorry, my lord, I'll take.
No, here you are for the opposite party, I understand. But what can be done?
Oh, my lord, 69. 69, yes, my lord, twice.
Twice time granted. ता पूर्व कौन लिख ले? To grant further opportunity, list on 28/11 कर दियो. 28/11. Yes.
70, my lord, there is a requisite file without postage. My lord, I'll file.
Mr. S.S. Mahapatra, AC for the petitioner, opposite party blank. The office note put up by the registry dated 29/11 or what is 9/11? Dated 9/11/2023 indicates that notice could not be issued due to non-filing of complete postal requisites. Complete requisites for issuance of notice by post. Registered post with AD. Para. The Learned Additional Standing Council seeks for further time to file the complete postal requisites. Prayer is allowed. Let complete postal requisites be filed within 2 weeks for issuance of notice to the opposite party. List after SR.
71, 72, my lord, same.
70. But this was the practice of not exactly for government council.
Nagar, while the accused was marketing on 2/5/2007 and the accused reported the matter at Sector 19 PS, but the ISC of the Sector 9 PS asked him to sure an affidavit and file the same. Accordingly, the accused filed an affidavit at the PS and stationery entry number 325 dated 10/5/2007 was made at the PS regarding missing of check. The accused also intimated at the bank on 3/5/2007 regarding missing of the check, and after receipt of the notice of this case, the accused reported the matter to Zhirpani PS. The copy of the FIR lodged at the Sector 9 PS has been marked and Exhibit A. It appears from it that 2 blank checks were lost, but there is no mention that these blank checks were signed checks. Further, if the complainant managed to get the checks, he could have used these 2 checks to
This is
file
speculation.
2 cases.
What is this behavior of this court? I don't understand.
Aye.
Court will make out a 4th, 5th, 6th case. If the complainant would have found it, then he would have done this. That is none of the court's business.
But what is
How
court has discussed?
then
What are the materials placed before?
so how the contents of the check were proved by you if it is lost? The court admits that yes, it was lost. Court has accepted.
It was the case of the accused.
The court has accepted.
Here, not accept. Trial court has not
Obviously, it
accepted
says
that plea
You
has
see,
not.
it appears.
Findings is in subsequent.
No, you are not reading 19 or you are preoccupied with whatever is favoring you. But 19 last but line padantu. Those FIRs were exhibited, marked as exhibit.
It appears from it.
Eta kon apun object karthile, disprove kale.
With objection.
Then what is the apun disprove karthile ki je eta file heini boli. Then it appears.
It appears from it
that 2 blank checks were lost. Full stop.
But there is no mention that these blank checks were signed checks.
How is it relevant?
It is a case of signed checks.
How it is relevant? Once the checks are lost from a prior date, from the date of issuance, then how do you say that they were filled by the?
So far,
138 kuhantuni.
So far, my experience is concerned, in a 138 proceeding, court has to see whether the check has been issued.
Your experience is very good, but you must abide by law.
Yes.
The law laid down by the Supreme Court and the High Court.
Yes, madam.
And there is no case of speculation.
Here the
the court gives a finding that it appears because the court cannot avoid those 2 affairs.
No, that cannot be avoided.
So then what is the relevance?
Only
then you have proved the signature on those checks.
My case is a signed check.
Not case, sir. I'm asking you, my case. Upon this chadon this is not a JMFC court. You are in a high court.
What?
138 case, my experience is that So when a specific question is asked, if you don't answer, then don't answer. But don't ask the court questions.
I'm placing that.
Sir, sir, after reading that, I'm asking you, or I'm not reading that. I will not read that.
That is
So
what
after the court gives a finding that the checks were lost.
Yes.
Then have you proved that the next question is have you proved the signature and the contents of the check before the court?
Yes, I have exhibited those checks.
So you saw that they were proved.
Check which alleged to have been lost.
Sir, ଆପଣ ଗୋଟେ ଯାହା ବି କହୁଛନ୍ତି ଜମା ସାରୁ ନାହାନ୍ତି. I'm asking you a specific question that where you have proved the court has dealt with that. The contents of the checks were proved.
I'm showing you lots.
Interesting. So the plea of accused regarding missing of the check does not appear to be good, sound, plausible, and cannot be easily swallowed.
Yes.
Then why this observation? Why this observation? Who has the learned court? The learned court in one line say that it appears from it that 2 blank checks were lost.
But complaint has filed all the documents.
Are complaint are ଆପଣ ତ ଖାଲି ତ ଗୋଟେ କଥା ଆପଣ as if you are arguing in that matter again, you are not re-arguing that matter. We are in appeal where there is a specific finding by the learned court, trial court, and the learned appellate court. So you have to deal with those findings.
Yes, ma'am.
ଆପଣ ଏଠି argue କରୁନାହାନ୍ତି to prove it.
No.
ତ କାହିଁ ସେଟା ବାରମ୍ବାର କହୁଛନ୍ତି complainant has filed.
Submitting before your lordship.
So please submit that where the court, because court gives 2 findings. That
one by
it
trial
is lost.
court, one by appellate.
No, the trial court says that it is lost. Then it says it is not plausible. Then why it is not plausible should be the reason. Then why you have proved that?
With such finding, trial court has convicted the accused.
Sir, ठीक अछि, that is understood. नले अपन challenge कहीं करथान्ते.
Then the accused.
आपण कोठी prove कले से the contents of check सीधा सेटिक आसंतु. What is the last number of the check you have issued, Mr. Patnaik? Mr. Patnaik.
Yes.
You are using a checkbook.
Yes.
What is the last date and number of the checkbook you have issued?
In this case, ma'am.
Your
last number check. Number I can't remember.
Date. Just realize how this court has speculated. I'm sure none of us can tell that which check was issued to whom on which date, unless it is specifically mentioned in the counterfile. Have you marked there is a counterfile maintained?
Yes,
then why it is maintained?
Since it is
and the court in page 19 last line, it apparently 2 checks were lost, it says. But then it goes into dissect what is the number, what is the date. It is not plausible. And suppose the court will give a finding it is not plausible. The reasons who will mention? Appellate court will mention or the High Court judge will mention?
The trial court.
Obviously, he has to mention it. That why he doesn't believe it?
Para 7.
And the problem is that this could have been because the stationary entry is after that affidavit.
Yes, ma'am. Basing on the affidavit.
Yes.
Para 7. You got how the complaint proof para 7 of the trial court judge.
No. The page you read page 20 makes interesting reading. Apana padhantu seithire. It appears from it that page 19 last line nu padhantu. The copy of the FIR lodged at sector 19 PS has been marked as exhibit A. Internal page 19.
It appears from it that 2 blank checks were lost.
The copy of the FIR lodged at sector 19 has been marked as exhibit A.
Copy of the
FIR. If you object kale A haba na X haba?
Aye, nahi, jota
objection hele A haba.
Jota complaint file karo seta 1 2 haba numbering. Jota accused habo A B habo. A B C D.
With objection kahe lekha hai ni?
Eita stationary FIR copy ta object kara hin.
Kari habani. Yes. Apano kaile object korchanti boli. Yes. Tapare?
The copy of the FIR lodged at sector 19 PS has been marked as exhibit A. It appears from it that 2 blank checks were lost, but there is no mention that these blank checks were signed checks. Further, if the complainant managed to get the checks, he could have used these 2 checks to file 2 cases.
Apone ta kon taku examine korthile?
Cross examination hichi.
ଆପଣଙ୍କର ଯୋଉ ଡିଫେଣ୍ଡାଣ୍ଟ କୁ ଆକ୍ୟୁଜ କୁ କ୍ରସ୍ ଏକ୍ସାମିନ୍ କରିଥିବେ ସେଥିରେ ଏଇଟା ପଚାରିଛନ୍ତି
ସିଏ ଦିଟା
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ କ୍ୱେଶ୍ଚିନ୍ ଟା ଜଜ୍ ଯୋଉ ଲର୍ନେଡ୍ ଜଜ୍ ନାଉ ଆଇ ଏମ୍ ଥିଙ୍କିଂ ଆ ଟ୍ରାଏଲ ଜଜ୍ ଯୋଉଟା ଭାବୁଛନ୍ତି ସେଇଟା କାରଣ ଆପଣ ପଚାରିଥିଲେ ଏଇଟା
ହଁ ଅଛି
ଏନିୱେ ଆପଣ ପଢନ୍ତୁ ୟେସ୍ ପଢନ୍ତୁ ଫର୍ଦର ପଢନ୍ତୁ
that these blank checks were signed checks. Further, if the complainant managed to get the checks, he could have used these two checks to file two cases against the accused. But the complainant has filed only this case in respect of check number 330754. So the plea of the accused regarding missing of the checks does not appear to be good, sound, plausible, and cannot be easily swallowed. Further, the accused has not mentioned anything.
Does the court have to swallow anything? Or the court acts as an umpire, just weigh the evidence? Court has no the limited role in our common law system. I am not conducting any inquiry. For that matter, any court is not conducting any inquiry. It is
Exhibit A shows
so obviously
FIR has been lodged.
Yes,
but the
and even the court doesn't say that the FIR doesn't mention, because if the check is lost, it is lost.
But the outcome,
yes, anyway,
outcome of the investigation has not been.
No, this language that it cannot be easily swallowed.
Yes,
what is for the court to swallow?
Further, the accused has not mentioned anything in the said report as to who were present with him at the time of missing of check. Further, he has not mentioned in the affidavit by Exhibit B regarding under what circumstances the checks were lost and who were present with him. When there is no mention that the complainant was present with him.
Every time something is lost, somebody has to be present with somebody.
No.
How many times, Mr. Patnaik, you asked? You just try to reflect on this. Whenever have you ever lost anything in your lifetime?
Not necessarily. Somebody is accompanying.
Most of us, all of us have lost so many things. Some paper, some key, some money, and somebody has to be present to witness that act. It is act. Then what is this logic?
That is why he lodged a.
No, you see, the problem is that the appellate court has noticed this. This kind of reasoning, reasoning has been noticed by the appellate court. Then read further.
Exhibit with
B
at the time of missing the check. Further, he has not mentioned in the affidavit by the Exhibit B regarding what circumstances the check were lost and who were present with him. When there is no mention that the complainant was present.
Read that slowly. That is very interesting.
When there is no mention that the complainant was present with him at the time of missing of checks, it cannot be said that complainant got the check. Further, the landed.
এটা কোন আপন প্রুভ করଥିଲେ?
কোটা
এটা ବି ଆପଣ ক্রস এক্সামিন করଥିଲେ না কোন হু ওয়াজ প্রেজেন্ট?
Yes.
Anyway, ছাড়ুন
ଯୋଉ চেকটা
ঠিক আছে পড়ନ୍ତୁ further.
Missing ଅଛି. Further, the landed counsel for the accused vehemently submits that the accused has filed 1cc case number 209 of 2010 before the court of SDGM Panpost under section 211, 379, 383, 406, 511, 467, 471 IPC against the complainant. The case has been filed on 15/5/2010, that is after more than 1 year of institution of this case. So merely because the accused has filed a case against the complainant, it cannot be held that the complainant managed to get the missing checks and misutilize it to file this case against the accused. Further, it is not understood as to under what circumstances the accused had kept the signed check in his handbag. It is further not understood as to why the accused brought the signed check in his hand bag when was marketing at Koilnagar at market. So the plea of accused regarding missing of the checks cannot be accepted with.
Now come to the finding of the appellate court.
Yes.
So where these findings have been dealt by the appellate court.
Paragraph 13.
5 ପଢନ୍ତୁ ଆଗ 5 ପଢନ୍ତୁ 13 କଣ conclusion କୁ ଯାଆନ୍ତୁନି ଆଗ discussion କୁ ଦେଖନ୍ତୁ.
As found, the learned trial court disbelieved the claim put forth by the accused appellant, analyzed the evidence on record, examined the documentary evidence, and held that the complainant has proved his claim that the accused had lawful debt as against the complainant respondent, and that the impugned check for rupees 4 lakhs, which was bounced, and thereby the complainant could prove the allegation against the accused appellant. The complainant has filed 1 CC 157 of 2009, claiming and asserting that the appellant took a friendly loan of rupees 4 lakh, assuring him to repay the same within a month and in order to discharge his enforceable debt and liability.
Then come to para 10.
Section 118 of NI Act directs that it shall be presumed, unless the contrary is proved, that every negotiable instrument was made or drawn for consideration. Section 139 of the Act stipulates that unless the contrary is proved, it shall be presumed that the holder of the check received the check for discharge of debt or liability. Thus, as per the provisions of Section 118 and 139 of the Act, in a trial under Section 138 of the Act, a presumption will have to be made that every negotiable instrument was made or drawn for consideration and that it was executed for discharge of debt or liability. Once the execution of negotiable instrument is either proved or admitted, as soon as the complainant discharged the burden to prove that the instrument was executed by the accused, the rules of presumption under Section 118 and 139 of the Act help him to shift the burden on the accused. The presumption will leave till contrary is proved by the accused that the check was not issued for consideration and in discharge of any debt or liability. The presumption is not in itself evidence, but only makes out a prima facie case for a party for whose benefit it exists. The above presumptions are all rebuttable. That means once the party on whom the burden lies produce evidence fairly and reasonably, tending to show that the real fact is not as presumed, the purpose of presumption is over. An accused under Section 138 of NI Act has two options. He can either show that the consideration and debt didn't exist, or that under a particular circumstances of the case, the non-existence of consideration and debt is so probable that the prudent man ought to oppose that.
Just kindly then I would request paragraph 12. Then read as mentioned above. Para 12, 8 lines.
Law does not require.
The accused appellant adduced evidence. So it is evidence deal question. जोटा कि trial court disbelieve कले, सेटा the accused appellant adduced evidence. Page para 12 पाइले.
Para 12. Law.
Page mark टा नहीं किंतु. Page कहीं पर भी नहीं. नहीं इतरे. Blank अच्छी. Para 12. Law, it starts, law doesn't require, then come to the 8th line.
And the accused appellant.
Yes, please. Yes.
Evidence asserting that on 2/5/2007, he had been to Koel Nagar market at 10 AM for marketing, met Sarat Acharya DW2 while the complainant was with him. His handbag was lost there. They searched for the same but failed. The bag had contained 2 blank checks, a pocket diary and other official documents. He claimed to have lost FIR, but police did not act upon his report. He sworn an affidavit on 3/5/2007. He had
Mr. Patnaik?
Yes.
DW2 has not been noticed by trial court?
No, he has been examined by the accused.
Exactly.
Yes.
Defense witness.
Yes.
Accused can produce kale? Acha, he is the
Accused
defense.
incident
Tero se acha trial court can notice kale ni? Kale no one was there.
DW1 evidence has not been taken into consideration. Findings.
Tikke mone rakhibe na, this is height of multitasking.
Aage.
ଆପଣ ଆଉଥରେ ତ ସେ ପେଜ କୁ ଆପଣ ଯିବାକୁ
ପଡିବ। ମୁଁ ବୁଝିଲି ଆଜ୍ଞା, ସେ ଯୋଉ ଫାଇଣ୍ଡିଂସ୍ ଟା ପଢିଲି ସେଟା ତ ସେ ଲେଖିଛନ୍ତି। Earlier findings ଟା ଯୋଉ ପଢିଲି
ଆପଣ ଯୋଉଟା ସେ ଦେଇଛନ୍ତି, she says that accused has not brought on record or proved that who was accompanying with him. That is how I asked you that every time I lose something, somebody should accompany me. Who will be the witness to my losing something?
But here it is a case.
You said that yes, no, but here DW2 has been produced.
Yes. Regarding loss of the bag.
In the market, because you see, something it is very peculiar to this case.
But
the Lorette trial court does not notice anything that would favor to the accused.
But appellate court, what they did.
Anyway, you read it. Read it further. No, I was surprised that this Sarat Acharya DW2 was noticed by was not noticed by the Lorette trial court.
Yes.
Yes.
He claimed to have lodged FIR, but police did not act upon his report. He sworn an affidavit on 3/5/2000. He had intimated the bank authority regarding missing of the checks. He had no idea about the complainant utilizing the check until he received notice from the court. He claimed to have lodged FIR against the complainant, but no action is taken. He claimed to have filed 1cc case against the complainant before the learned SDGM Panpost after he could know of the fact of use of check by the complainant. On behalf of the accused appellant, Exhibit A, the copy of the FIR bearing the seal of Zhirpani PS, and Exhibit B, the affidavit found to have been shown in on 3/5/2007 are admitted into evidence. The carbon copy of the FIR admitted into evidence as Exhibit D and Exhibit E is the certified copy of the order by the SDGM Panpost in 1cc 209 of 2010. As it appears, Exhibit A and D are admitted into evidence with objection, but as I find, the learned lower court didn't order on them. Rather,
Then
he has-
Mr. Pause for a moment, Mr. Patnaik. In fact, you objected to that. So that is now answered.
Yes.
But he has not ordered on them. Rather, he has relied on those documents. And in fact, he has relied on those documents.
Yes. Rather, he has relied those documents. The
Yes.
appellant was subject to cross-examination by the complainant. It is admitted by the accused that the checks which were there in the bag were not signed. He was
again. तांको फाइंडिंग देखले
आया ट्रायल कोर्ट फाइंडिंग
कौन देले
सी तो ये जो एग्जिबिट हला जो डॉक्यूमेंट एफआईआर हला 1cc के
मने रखियो सर
इट हैज नॉट बीन डेल्ट विथ बाय द ट्रायल
नो कौन फाइंडिंग देले
सी फाइंडिंग देले जे नोबडी वाज देयर व्हाइल द
सेटा तो भूल गेला DW2 थिले सम रिगार्डिंग साइनिंग ऑफ नॉन साइनिंग ऑफ चेक कौन देले फाइंडिंग
ट्रायल कोर्ट
हाँ There is a specific finding.
Accused has completely failed to substantiate the plea.
Specific finding अछि मु कहि देबी किछि बड़ कथा न मु भाबुतले आपण नोटिस करते बेले आपण तो देखौन सेटा स्पेसिफिक से फाइंडिंग दैचंती that is how this his judgment has been overturned. The problem is that the brief is not page marked. से जोटी डिसबिलीव कले से सेठी फाइंडिंग दैचंती
Paragraph 14 days.
पढु नांती
It has been already discussed in the foregoing paragraphs that the accused has failed to substantiate his plea and to report the
सेटा
presumption.
पढंतु नहीं से स्पेसिफिक फाइंडिंग दैचंती चेक और साइंड और अनसाइंड केते थरा गोटे कथा कहबे आपन doesn't look nice. अपन जोटा पढुथिले जोटे आरंभ कले has been marked as exhibit A. सेटा को पैराग्राफ रे अछि
सेटा appellate court or finding टा मु पढुथली या पूर्वरु जस्ट जोटा
अपन आमे when we started discussing we went through the
page 19
again
page 19 of the trial court judgment.
हां सेटा जेतु पेज मार्क नाही मते मिलिवारे कष्ट होउछ
रखि देउ न लागुड
नाही किछि रखिवार नाही कोन रखिवार अछि पेज 19 रे आपण देखंतु लास्ट लाइन
bottom
हां
2 lines exhibit A It appears from the 2 blank checks were lost,
but there is no mention that these blank checks were signed checks.
signed checks.
ଆପଣ କିନ୍ତୁ evidence କଣ ଦେଲେ?
Signed check issued in my favor.
Blank check, lost check. ଆପଣ ବୁଝିପାରିଲେନି.
Lost check
You
is
you are
sealed.
also, you see, the trial judge has written such a judgment that the counsel, session counsel like you also is losing the track. There is a specific finding. ଆପଣ ଦେଖନ୍ତୁ ବର୍ତ୍ତମାନ mark କଲେ ତ? But there is no mention that these blank checks were signed
Blank
checks.
check or signed check.
To get the checks, he could have used the 2 checks. Then ତାପରେ ଦେଖିଲେ
ସେ para 12 ଟା ପଡୁଛି ଯୋଉ appellate court ର.
ହଁ.
But
ସେ evidence deal କରିଛନ୍ତି ଯେତେବେଳେ appellate court evidence deal କରିଛନ୍ତି.
middle ରୁ ପଡୁଛି, he sworn an affidavit on a 3/5/2000 he had intimated the bank authority regarding missing of check.
ତାପରେ DW1 ପରେ DW1 ପରେ ସେ specific ଦେଇଛନ୍ତି.
He supported DW1. He is found to be a witness to the loss of the handbag by accused. His evidence is of no further avail. Exhibit A is found to be an FIR registered with stationery entry 325 dated 10/5/2007. It discloses that the complainant had lodged a report
ଆପଣ ସେ signed କଥାଟା ଛାଡି ଦଉଛନ୍ତି.
ଆଜ୍ଞା.
Trial court କହିଲେ he has not adduced evidence, not mentioned whether signed or blank. But here you deal with it has been dealt in the evidence.
In this paragraph, evidence has been dealt with.
କଣ blank check or signed check? Page mark 9, that is the whole problem. ଆପଣ ପଢିଲେ but as I find the learned lower court did not order on them. ପାଇଲେ?
Order on them.
Order ତାପରେ କଣ ଲେଖା ହେଲା?
Rather, he has
relied those documents. He means the learned trial court.
Yes.
He is not a correct use of English. The appellant was subjected to cross-examination by the complainant. It is admitted by the accused that the checks which were there in the bag were not signed.
Were not signed.
ଆପଣ evidence ଅଛି not signed ବୋଲି.
ଆଜ୍ଞା.
ଆଉ trial court କୋଉଠୁ ଆଣିଲେ ସେଇଟା? Either this is right or that is right.
It is the case of the accused. ସେଟା signed
obviously ଆପଣ ଯଦି accused case file କରିବ ସେ କଣ કરે but what is the evidence on record when the appellate court is discussing that ଆପଣ cross examine କରିଛନ୍ତି that it is not signed, but the learned trial court has said that it is not mentioned whether signed or not mentioned. Then problem କଣ ହେଇଛି କହିଲେ?
ଆଜ୍ଞା.
Trial court has noticed the FIR, not discussed the evidence of what you have adduced by cross-examining. Read further. Today there will be no time. Anyway.
But the appellate court has reversed the finding.
Obviously, it has to be reversed.
On the demand.
You see the
notice of demand.
You see first of all, the learned trial court is not investigating. Is not at all investigating whether the check was issued or not. Then what the trial court is trying? Is trying to determine. The learned trial court cannot substitute its own feeling, sentiment, emotion,
that cannot.
Perception.
That cannot. What is the material on record?
What is material on record?
But the
and the learned trial court has simply not ordered on that, rather even objection. He has not noticed even the cross-examination. Obviously, he was cross-examined that whether you signed or not, and he said that it was blank checks.
Accused has been cross-examined.
Yes, and he says that it is a blank check, not signed. And the learned trial court gives a finding. It is not sure whether signed or not mentioned whether signed or blank. How is it relevant?
But the appellate was a reversion finding on the notice of demand. Ultimately, in para 14 of the appellate court judgment, your lordship will find.
The whole problem is that notice has also not been discussed. what is the essential ingredient of notice,
Notice.
whether section 27 is applicable or not, General Clauses Act, because the general principle is generally a specialibus non-derogate. You cannot derogate a special statute by utilizing the general statute. And in so many cases, due to notice, this technical offense is not made out as far as 138 is concerned.
It is purely a technical.
Highly technical. Highly technical.
One-
Because
one
first
day
time,
delay in-
first time it is a milestone as far as civil disputes are concerned.
Yeah.
Till 138 came into play, NI Act came into picture, it was a civil dispute. It is a civil dispute.
But the procedure followed under the criminal procedure.
Till it was not criminalized.
Yes.
It was not criminalized. Dishonor of check was not criminalized initially.
No.
Because
Subsequently,
Negotiable Instrument Act, as it state, because prior to that it has a predecessor also.
even suits are being filed.
Suits were filed, claim suits were filed. Yes,
Money suits.
yes, money suits. 82 lekhile. Swarup Kumar Patnaik for the petitioner. Mr. Mahanti, naki nahanti ki apananko? I didn't notice that. Udit Ranjan Jenna, Udit Ranjan to thile aji kod pole. Opposite party none. The learned counsel for the petitioner made submissions in extenso. Since no further time is left for hearing of the matter, list on when do you want, Mr. Patnaik?
1 week after.
No, 1 week after exactly ହେଇପାରିବନି. It has a variety of matters specifically urgent ଅଛି.
As your lordship.
ରହିପାରିବ 24 ରେ ରହିଲେ ନା 28 କୋର୍ଟରେ କୁହନ୍ତୁ.
ଆଜ୍ଞା.
Date
28.
28. List on 28. Yes.
83. My lord, on behalf of
Then Mr. Patnaik, I don't understand how the learned court missed DW1.
DW2.
DW2 whatever. So that this is जो आचार्य ना कौन.
मुझे से क्रॉस एविडेंसटा अछि मुझे.
Cross examination तो छाड़ दियंतु.
आगे.
Cross examination of DW1 it has missed. But DW2 how it can miss?
Exactly.
Because if the courts are presumes a hypothesis that no one was present. But surprisingly, the appellate court finds
that part of finding
no,
what your lordship said.
No, not lordship. It said appellate court. ମୁଁ କୋଉଠି finding ଦେଇଛି. ମୁଁ ତ ଆଜ୍ଞା ଶୁଣୁଛି ଆପଣଙ୍କୁ.
କୋର୍ଟ ଯୋଉ ନିଜ
ମୁଁ ଆପଣଙ୍କୁ ଯୋଉ ଶୁଣୁଛି ସେଇଥିରେ ମୁଁ ଦେଖୁଛି ଏଥିରେ appellate court finding ଦେଇଛନ୍ତି learned sessions learned additional session judge.
Trial court ର finding ଟା ଯୋଉ
ହଁ ଆପଣ he could not have missed the evidence.
material based
obviously ଆପଣ examine କରିଛନ୍ତି ଆପଣ ବି ତାଙ୍କୁ cross examine କରିଛନ୍ତି.
material based finding ରହିବା ଦରକାର.
ହଁ. Yes.
My lord, on behalf of the Bharati Das, is Bharati Das.
कितने number item कहले?
83.
83. Next matter. Your name, sir?
J. Raut, Jagabandhu Raut.
Jagabandhu Raut on behalf of Bharati Das for the petitioner.
Urgent the matter.
Opposite party blank. The learned counsel for the state ପାଇଁ ଅଛନ୍ତି ଏଥିରେ 83 file ଅଛି.
My lord, copy of the brief, my lord.
Copy नहीं?
No.
State ଲେଖା ହେଇଛି. Opposite party blank, the learned counsel for the petitioner seeks accommodation. As spread for list on. From 83 till 100, since no time is left, any mention? Serially you can go.
84 tag and award dinas.
Mr. S.D. Rai for the petitioner.
Yes, my lord. 85, sorry, 85.
Sorry. I'm sorry. ଟିକେ ବସି ଯାଆନ୍ତୁ ତାହେଲେ. ତ serially ଯିବାକୁ ପଡିବ. Mr. S.D. Rai for the petitioner.
Yes,
Mr. Rai.
84.
84.
1 week after us.
So Somdev Rai for petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation. As spread for list on 612.
Deep list.
Yes. No time is left for hearing. 85, Mr. Jenna.
Again, जेवे रखते
Same order. Date कौन तो 85? 5/12.
December 3rd week जेवे.
No time left लिखिबे. तापर लिखिबे Lord Counsel for the petitioner's accommodation. Yes.
86.
Mr. NP परिजा appear करथिले ना?
85 का date.
85 केबे कहले?
Date था sir.
5/12 ना further time sir?
था 5 बार था.
5/12. 86 Mr. K. Jenna.
Next, any take.
KK Jena for the petitioner. Opposite
the
party
opposite
blank. The learned counsel, same order.
Well, I am for the
No
opposite.
time left for hearing the matter today. Learned counsel for the petitioner seeks accommodation. Mr. Dayanandi Mahanti, I'm sorry.
Opposite bit.
Mr. Dayanandi Mahanti for the opposite party. Mr. 11, appearance likhe le. No time left for the hearing the matter. Hearing of the matter. Learned counsel for the petitioner seeks accommodation. List on 11/12/2023. 87, 88. Yes, 89. Mr. PK Maulik. 89 lekhantu. Mr. PK Maulik for the
88
on
I am
behalf of
there.
S. Mahapatra. I'm sorry.
88 I am there for the OP.
88
for the
petitioner none.
I am for the petitioner, my lord. I am in VC, my lord, for the petition.
Mr. 88, Mr. Mohit Agarwal for the petitioner. Mr. S. Panda for the opposite party. Sudipta Panda for the opposite party. No time is left for hearing the matter today. As prayed for list on, Learned counsel for the petitioner, list on 7 bar. Yes. 7th of December.
Yes, your lord.
Yes.
89.
PK Malik on behalf of S. Mahapatra for the petitioner. 89, Mr. Standing Counsel. 89, Mr. Standing Counsel for the state. Learned counsel for the petitioner seeks accommodation. As prayed for list on 11/12/2023. Then 92, 97.
92.
92.
92, my lords.
92, I am for the Union of India, my lords.
92, you are Union of India.
Yes.
92, Mr. Your name, sir?
Pratik Das.
Mr. Pratik Das for the petitioner. Mr. Prabhu Prasanna Behra,
My lord.
CGC.
Yes, ma'am.
For Union of India.
For the opposite parties, all the opposite parties.
For the opposite parties.
Yes.
No time is left for hearing the matter. The learned as prayed for list on 19th of December. You want further time?
No, my lords.
19th of December.
Interim order to continue, my lords.
When last extended, sir?
It's extended till today, my lords.
Till date?
Till
1/9/23 was the
1/9/20.
1 and after ASEAN.
My lords.
Interim order as passed earlier shall continue till the next date.
Obliged.
Oh, this is a 23 matter. Okay.
93.
No, ekatra 93 to state 97 डाकंतु की भी थिबे ना.
93 to
Take,
97.
I want to time, my lord, for instruction.
93 you are there.
My lord.
Miss S. Nanda for the petitioner. Mr. 93, Mr. Standing Counsel. Mr. Standing Counsel for the state. Learned counsel for the petitioner seeks accommodation to obtain instruction. As prayed for list on 15th
2
December.
weeks after, my lord.
15th December.
No, my lord, I'll see week re mu nahi. Moro next week re karantu.
1/12.
Yes.
1st of December.
95, Lordship.
Mr. Rajesh Kumar Mahapatra for the petitioner. Mr. Standing Counsel for the state. No time left for hearing of the matter. List on, when do you want, Mr. Mahapatra?
Lordship, I think it will be,
8/12.
yes, or 18/12 will be better, Lordship.
18/12.
ठीक है, भला होता.
18/12.
Grateful.
Yes.
And there must be interim order, Lordship, that may kindly continue because it's a
When last extended, sir? 93. Last date kontu.
Hard admit on bail now.
Before ASEAN resurfacing or after ASEAN resurfacing?
नहीं see तो before ही आएगा the 13
So please don't mention.
Oh,
If there is no
क्या थी वो?
judicial order vacating the order, so don't bring in that. You are inviting that problem.
Grateful, Lordship.
Yes.
I am sorry for it.
I'm not. Yes.
I got your point. Sorry.
Yes.
See, item number 96. But I need
Your name?
It is Sri Maharana.
Itisri Maharana.
On
On behalf of B. Panigrahi.
Yes, yes.
MS.I. Maharana on behalf of B. Panigrahi for the petitioner.
I need some time, Lordship.
State, Mr. Standing Counsel. Because since there may be some cases where vigilance is there, please check and update the court master.
File is not there.
Just verify, Mr. B, because it could be vigilance also. The state vigilance is also mentioned state. The learned, no time is left for hearing the matter. The learned counsel for the petitioner seeks accommodation as paid for list on 19th of December.
Okay.
Yes.
98.
Mr. M.R. Das on behalf of Ashok Das for the petitioner. Mr. Standing Counsel for the state.
I don't know, say counsel for the state because I don't have the.
No, because in the order sheet, the name is mentioned.
Yes. All.
So you
No.
please verify and then intimate.
No issue. No issue.
No, there is no problem in mentioning your name. That is
Right.
there. But the only difficulty that if there is a special counsel, then
Yes.
98 praise for accommodation. No time is left for hearing of the matter. The Learned Counsel for the petitioner seeks accommodation as prayed for list on 15th December 2023.
99, 100.
100 madam. Mr. H.N. Mahapatra for the petitioner, Mr. Standing Counsel for the state. No time is left for hearing of the matter. List on, when do you want, Mr. Mahapatra?
Not the second week of December.
List on 15th of December. Kebe got a date got it. 14th of December 2023. Passover kish royal.
Nice.
Thank you.